Milord, the other two petitions can be closed.
Closed.
Actually, what had happened, Milord, it pertains to the same police station.
Mhm.
In 1707 of 26, I have been given absolute bail by
Okay.
this honorable court.
Okay.
Therefore, Milord, 865 of 26 and 1583 of 26, I am not pressing.
Okay.
But Milord will kindly mention the fact
But
in
is
view
this
of the
a-
order.
yes, the absolute bill has been given in this I cannot repeat.
1707.
Okay. Okay.
I have informed him. I have informed him.
Has to be submitted in this case, madam. So I pray, madam, is there any order may be passed, madam, at the time of?
No, we have informed him. We have informed him. But do you know we have informed him?
We have already informed him right now.
He said they have no objection. No, my petition I am withdrawing. How can they object, my lord?
He's withdrawing the petition.
They have become PP does not mean they can make all submissions.
Then he's withdrawing his petitions. He's saying that AB application is disposed of and other petitions I'm not pressing.
Huh.
No. Whatever he is seeking, he has filed a bail, right? Bail application,
Three petitions.
whatever.
Ah.
Now he is saying that I don't want to press it.
Yes.
Yeah, can you stop it?
Then
Similar text, some two petitions have been filed, my lord. That is where the otherwise I would have made a mention, my lord.
my lord,
No,
they are-
I'm not understanding what you're saying. See, I mean, 3 AB applications have been filed.
Yeah.
One AB application, they have got an absolute order.
Yes.
Now they are saying ki, like they have, I mean, in view of whatever reason, but I mean, I'm not concerned with I'm not concerned with anything. They are saying that I don't want to press it. Then what you can do? If you want to arrest him, arrest him. If there is some
Yes.
some issues are there, then
Now I am.
তো কোনটা কি কইছে? My lord, we informed him. He said they have no objection. That's why I told him to please inform him that we are mentioned. My lord, they are under the. I'll explain. My lord, what had happened? There is a. My lord, there is a cooperative society. Now the cooperative society, they are on to, my lord, the business of microfinance. Now there is some allegation by depositors that the money which they have paid has not been received back. So therefore, based on that, my lord, there was a complaint before the Deputy Commissioner's office. My lord, apprehending that we may be arrested, we approached this honorable court in 865 of 26.
yes,
There, my lord, we have been given an order, no coercive action.
okay,
Then what happened, my lord? Cooperative department again filed a complaint
53.
with the same complaint, same allegation. Then we filed petition 1583 of 26. There also no coercive action. Finally, my lord, an FIR was lodged in Polasbury police station. There, in respect of that, we filed AB 1707 of 26. My lord, their apprehension is that these two facts we have not mentioned. My lord, in fact, the orders passed in 865 and 1583 were produced before these honorable courts. My learned friend can check the video. The other day, an submission was made by Mr. Borua that we have suppressed this fact. Well, now I'm holding the Millard video. In fact, we wanted bail order based on the order passed in first two case. Now there is, in respect of the offense, there could be only one PS case. Now one PS case has been registered, Polasbury PS. There, Millard, we have been given absolute bail. So why should I pursue the other two case? That's why I want to withdraw.
I am not clear with the facts, my lord.
If you're not clear with the facts, then you should not mention.
So, my lord, I am paying, my lord, let him come, my lord, I have informed him, my lord.
Okay. I'll come after some time.
He's coming.
No, it's okay. No, Millard, only problem
No,
is I
he-
clear informed
He
him.
may not be required also. I mean, if he's there also, we'll pass that.
After some time. Only thing
Okay.
is, Millard, second half I'll not be there. If you
No,
lost,
we'll
kindly
take-
text
we-
at the
we-
matter
we-
on 12 o'clock or something. Deep clear.
Yes.
Item number 53 supplementary issue. Additional affidavit is filed at my copy.
Why do you keep on filing additional affidavit? Why?
Directed on last,
For what?
annex, last bill order, rejection order.
Okay. I mean, I don't know why this petitions are being allowed by registry without the bail order. Why do you annex it, Michelle? Okay, we call it.
Now Mr. Bodua has come. It is
Yes, Mr. Boro, but is there anything you can oppose to?
My lord, the fact is that, my lord, they have filed under two bail applications, my lord. In both the bail applications, my lord, at that point of time, my lord, no FIR was registered, my lord. So
Correct.
this honorable court directed us to obtain instructions.
Instructions, yes.
So we have obtained instructions, my lord, and individual CD received, my lord.
Hmm.
But my lord, why the two bail applications were moved, my lord,
Hmm.
this honorable court already granted for no court selection.
Correct.
That means, my lord, in case of Polasbari police station, my lord,
Hmm.
any case is registered, they will not be arrested, my lord. They are fully protected. Then, my lord, when we received the case diary, my lord, on that day, my lord, they sought for time, my lord. They sought for adjournment, my lord, we did not make any objection. Thereafter, my lord, they have filed another bail application, my lord, before this honorable court. In that case, my lord, which was registered as a Polasbari police station case number 171.
Correct.
That is the main case, my lord.
Correct.
And, my lord, the coordinate bench of this honorable court, my lord, granted absolute bail, my lord, on the very first day, my lord.
Correct.
Without producing the case diary.
Correct.
Now, my lord, in that bail application, my lord, that is 1707, 26. If lordship peruse the paragraph 7 of the bail application, there is no mention about that earlier they have preferred two bail applications, my lord, which are pending.
But that is a technical hitch. I mean, like there is a technical issue.
That is why, my lord, now they want to, my lord, withdraw those bail applications, my lord, where there is no court selection. My humble submission, my lord, while this bail application 1707 was, my lord, filed, that is filed, my lord, by suppressing material fact that, my lord, earlier two bail applications were already filed, my lord, wherein these honorable court protected them, my lord. It is not that, my lord, this honorable court has not protected them.
No. What I mean, if they want to withdraw it, like what is the problem?
No, problem is that, my lord, they have filed
No. Tell me
What
one thing,
bail
Mr. Borua. Somebody is apprehending arrest. They have filed an application before this court. Now they are saying, "Ki, like, I don't want to pursue this case. I don't want to pursue the bail application." Can you stop him?
Yes, my lord.
If you have something, some issues, then you go and arrest him.
We do not have any issue, my lord. This honorable court, my lord, protect somebody.
No. Protect somebody. No, protect somebody. This, I mean, AB application not pressurizing means it is dismissed. It's not about the interim order, whatever is passed, that is gone.
But,
Then-
my lord, when they are already protected, my lord, in connection with Polasbari police station.
Polasbari police station case, they have already been protected. That is a different thing. But as far as these other two bail applications are concerned, wherever like wherein the court has passed no coercive action, now they want to withdraw it. Then now, I mean, is there anything? But I mean, I can say no, you cannot withdraw it.
One thing, my lord. While we produce the case diary, my lord, in connection with those cases, my lord, wherein, my lord, they were apprehending arrest. At that point of time, my lord, no case was registered, my lord.
Correct.
At that point of time. That is why, my lord, this honorable court granted them.
Now later on case was
Now,
filed.
my lord, let me complete, my lord. Now, my lord, while we produce the case diary, then we have said that case has been registered, my lord. Thereafter, my lord, they filed the additional bail application number 1707, 2026, by suppressing material fact that no bail application is pending, my lord. Whether, but the other two applications, is this connected to, is it not connected with Polasbari police station case, my lord? This is very well connected with Polasbari police station case number, my lord.
No, I got
That is
it.
why my humble submission, my lord, let the notice be issued to the petitioner, my lord, why he has filed the third bail application, my lord. While this honorable court has already protected them, my lord.
No, already.
Because police will not be arrested him, my lord. Even this Polasbari police station case is registered at a belated stage, my lord.
No. See, there is only one case filed, right?
Yes, only one.
Only one case filed. There is Polasbari police station
Yes,
case.
my lord.
Now, Polasbari police station case, he's got an absolute bail.
Yes.
So if you have any problem, you come for cancellation of that.
Polasbari-
Correct. Now, the other two application, you are saying that there was no case filed at that point of time.
Yes.
Correct. Without case, they just came here with an apprehension. Now they apprehended it and like this court protected them. Now they are saying, like, we don't want that protection.
Yes.
I don't want that
No,
protection. So
no.
they want to withdraw it. So what is the problem?
No, problem is that, my lord, they have filed a third bail application by suppressing material facts.
So, my lord, this,
And all
now I
other
think
two
a
bail applications
new
already pending, my lord.
provision has been inserted in CRPC or BNSS that permission of Ranjan Borua is required to file a bail petition. My lord, my learned friend is making a submission of suppression of material fact, my lord. Will kindly see this video, my lord. Hey, uliya diya na, ki kori asa? Voice to diya.
Petitioner will appear before.
No, na, more submission to media ki.
So we'll do one thing, Mr. Chaudhary, we'll take it up. I mean, if you're free, then like, I mean, 12 o'clock. Let them
Yes,
come
12
to 12 o'clock.
Not 12 o'clock, my
When?
lord, because I have also some other
When?
at 2 p.m.
No, he's saying he has some problem in the second.
PM, I'm not there today.
Let it,
Let it be at 1:45, my lord. Sorry, 12:45.
12:45 or whatever.
we'll try to, otherwise, my lord, my.
Put somebody
If
there.
you'll be waiting for me, my lord, again, it will be
That
problematic.
put somebody there in your place for some time.
No, my lord,
12:30 will take
my
it.
lord, no, my lord, lordship will kindly take this matter very seriously. It is not a question of state. It is a question of a PP taking initiative in a particular case. And lordship will take this to the logical end.
Yes, I do not have any.
Yes,
objection, my lord.
this issue should be
Because,
taken
my
to the
lord, I have
logical
also
end.
filed a bail application, my lord. Why,
Yes.
why this is necessary,
Yes.
my lord? There is no bail application is pending, my lord, before Indian High Court, my lord.
I don't
Why
understand.
this step is required, my lord, then in bail application,
No,
my
but-
lord?
My lord,
Do I have any parcel, my lord?
No. See, Mr. Borua, I understand that there was some, maybe there was some technical this thing, but now thing is that they want to withdraw it. How can I
No,
stop
my
them?
lord, my lord, I am apprehending arrest in a case. First Deputy Commissioner, second Cooperation Department, third FIR. Who prevents me from filing 3 bail petitions, my lord?
No, nobody.
Then, my lord, while I moved the third petition, I placed those 2 orders. Now their allegation is that we have suppressed the fact. That's why I want to, lordship will fit in here, my lord. My lord, I have placed those 2 orders. Based on those 2 orders, I prayed for bail. And that is why bail was granted.
That is not recorded in the order of the
No,
bail.
that is not recorded, but my lord, my video is very much.
Okay, we'll take it up at 12:30. 12:30. Borua, please be here for some time. 12:30 will do it. 12:30 will do it.
Lord, I don't know, my lord, what has happened in this case. The other day also, my friend was opposing like anything. I want to withdraw the petition. That's all.
No,
No,
withdrawing.
the other day I
withdrawing-
mentioned because my lord, one matter was.
No, forget. No, let us hear at 12:30. 12:30 we are fixing it.
My lord, the
So-
other day, one matter was before lordships, other matter was before the Honorable Court of Sanjeev Sharma. Then we mentioned before lordships on Monday.
Yes.
That
was-
as lordships posted the matter today.
Hmm.
There, my lord, in Sanjeev Sharma's court, my learned friend created a ruckus.
Hmm.
As if, my lord, heaven has fallen. As if, my lord, we should take permission from him.
What
If that is his-
my lord, to
if that is his
statement
contention.
in the bail application number 1707, my lord, then another 2 bail applications are pending, my lord. So, my lord, petitioner is the same, my lord. Allegations are the same, my lord. What prevented them, my lord? Then?
My lord,
No,
orders were produced.
No, see, there are certain bail applications have been filed. I mean, maybe the client, I mean, I don't know. There may be lot many reasons, but only thing is that like, I mean, disclosure. So if the bail orders have been already
Yes.
handed over, then that objection goes. Anyways, we'll take it up at
Okay,
12:30. 12:30 we'll take it up.
May I please, Lordship? Lordship, I beg to mention item 35, Lordship. CD
Hmm?
not received, Lordship.
One second. Item number
35, Lordship.
35,
CD
yes.
not received, Lordship. Interim not there. Interim not
CD
there.
has not come. Okay, item number 35 read, CD not received, let the matter be listed after, let the matter be listed on, huh? If the charge there, matter, let the matter come, we'll pass an order. Okay? Hmm.
Item number 30.
30, yes. 30 case there is not there. Okay, CD is awaited, let the matter be listed on 25th, 25th, yes.
Lordship, may I beg to mention item number 31?
Huh?
Item number 31, Lordship.
31,
Yes,
yes.
sir, Lordship, my senior is not at, right now, he's out of station due to unavoidable some circumstances. So
Okay, on the prayer of the learned counsel appearing for the accused applicant, let the matter be listed after 2 weeks, after a week. On 20th, 20.
Lordship, I beg to mention item 62 of survey.
Hmm.
This one I for modification of the order.
Hmm?
First, I for modification of order as per the honorable justice.
Honorable Justice, the why it has been listed here.
So it is probably wrong.
You are registered to list this matter before the appropriate bench.
Can I not find it?
Now, I will not pass any order. Registry to list the matter before the appropriate bench.
May I please, your lordship? Lordship, I beg to mention item number 46.
40,
46, lordship.
46, yes.
With consent of the other side, lordship, and the adjourn for 2 days, lordship. Next date may be fixed, lordship.
47, on the
next
prayer of the learned counsel, you are appearing for petitioner.
Yes, lordship.
On the prayer of the learned counsel appearing for the applicant, let the matter be listed. When
Next week maybe.
let the matter be listed in the in the
Date
next
may be
week.
fixed,
Next week, he submits that he has already taken consent of the other side. Full stop.
Date may be
Next
fixed, lordship.
week.
Yes,
Next week on
any date maybe.
not next week. We will put it on 25th.
20. Oh, bless you.
Let the matter be listed on 25th.
I am on behalf of PROCEEDINGS for responding number 2. Council is unable to attend before due to some medical.
Okay, MS so and so, the learned counsel appearing on behalf of MST Parasar, the amicus curiae representing respondent number 2. Let the matter be listed after. Let the matter be listed after 2 weeks. Have you intimated the other side? You should intimate the other side when you make a mention. We have not distributed the slip, so you should intimate the other side. Okay, we are. Please mention that she is not keeping well or something like that. Personal difficulty. Let's see. So that we can tell you. Okay. After 2 weeks.
May it please your lordship. Your lordship, with the consent of the other side, I beg to mention item number 15. Your
15.
lordship. Yes, your lordship. The matter may be adjourned for the day and fixed another date, your lordship.
Your name?
F. Rahman.
Your name is not there.
SK Nargis, on behalf of SK Nargis, your lordship.
Learned MS so and so, the learned counsel appearing on behalf of MS SK Nargis, the conducting counsel in the conducting counsel. Let the matter be listed after 2 weeks.
Your lordship, date may be fixed.
After 2 weeks, she has submitted that she has taken consent of the counsel appearing for the other side. After 2 weeks.
So please. May I please your lordship? I beg to mention item number 36. Item number 36, lordship.
13.
36. 36.
3.
36.
6.
Yes, lordship. Lordship, the engaged counsel due to his personal difficulty.
Speak a little bit louder. We can't hear you.
The engaged counsel due to his personal difficulty could not appear before this court today. So kindly matter may be adjourned for a day.
Okay, on the prayer of the Lord.
Unfortunately, lordship, in this case, I am the informant as well as the victim, lordship. Lordship, the petitioner in this case is the son-in-law of my next door neighbor. And lordship, he has cheated me an amount of rupees 1,80,000 to invest the said amount in the share market, but not a single party he has invested. But even then, it is on his personal difficulty as because Navakolta is contesting in the election, lordship. May I pray any date next week, Monday or Wednesday, as because CD is also here.
Okay.
And that observation is also there in the earlier order.
You have been cheated.
Yes, Lord. What can be done, lordship? My next door neighbor.
Very, very bad.
And lordship, interim is there, lordship. So interim may continue. Interim is there, lordship.
That interim was granted.
Okay, MS owns.
That the amount will be refunded in 3 installments, but not a single party gate.
Okay, we'll take it up. Next week, when do you want?
Monday or Wednesday or Tuesday, as per your lordship's convenience.
When is the election? Election?
Election is on Friday. That is the
Next week.
Monday or.
Okay, on the prayer of the learned counsel, appearing on behalf of Mr. N.K. Palika, the conducting counsel, let the matter be listed on 18th.
18th Tuesday.
On 18th.
I have one question.
May I please, your lordship? Lordship, it's a 483 bail application, lordship. The allegation upon me, lordship, 351-2, 351-3, 69 and 89, lordship. Lordship, this is a charge sheeted matter, your honor, and presently pending before the SDGM 1 at production stage, lordship. And in connection with this instant case for last 65 days, I am behind the bar, Lordship. So as the matter is charge sheeted, so it will take 3 to 4 hours to for dispose of the case, Lordship. So my humble prayer for the time being, I may be allowed to go on bail, so that I can face the trial, Lordship.
See, we have cited so many sections, but I don't remember what is there. So you read the FIR.
Lordship, it's a long affair. Affair is on
I have
Case
time.
num-
I have sufficient time. You read it.
Lordship. 15, page 15. Yes, Lordship. Lordship, the complainant in her affair stated that paragraph number 1, I was in a relationship with Mr. Shivananda Singha. He repeatedly represented that he loved me and intended to continue a future with me. Then paragraph number 2, our first physical relationship took place in April 2025 at his residence while we were in a relationship. Then paragraph number 3, subsequently I discovered that he had married another woman. This fact was concealed from me and did not inform me about his marriage. Then paragraph number 4, even after his marriage, he continued to contact me and resume the relationship. He repeatedly told me that his wife was allegedly cheated on him.
Heard, Mr. Your name?
Ardas.
Ardas, learned counsel, appearing for the accused applicant. Also heard Mr. MP Goswami, learned APP for the state. This is an application under section 483 of BNS 2023, playing for granting bail to the accused applicant in connection with PRC case number 2328/2026 corresponding to Bosista PS case number 181/2026 under section 351 in bracket 2, 351 bracket 3, 69 and 89 of BNS Act 2023. Charge sheet in the instant case has already been filed. Date, you give me the date.
Order. From the order, it is taken as justification.
Have we annexed the charge sheet?
It's not the next man.
We are not getting the charge sheet, not getting the copy.
It is stage of the copy perhaps.
Then you write, it has been submitted, the charge sheet in the instant case has already been submitted. Registry to call for the TCR in connection with PRC case number 2328/2026 from the court of the learned SDJM number 1 Kamrup Metro. Full stop. Let the matter be listed when?
Around 25th, my lord.
Okay, 25th.
Lordship.
As on today, Lordship, 23 days, the petitioner is behind the bar. And Lordship, this is a case of suicidal.
Okay,
By the victim,
heard
that
Mr.
is
G.
the-
Pramod, the learned counsel, appealing for the accused applicant, also heard.
Lordship, if I may. Lordship, I am appealing for the victim as well, father of the victim as well as the
Your name?
informant. K. Jain, Kunal Jain, Lordship.
By Mr. MP Goswami, APP, and AK Jain for respondent number 2.
Lordship, I am not.
No,
repeated,
sorry, for the informant. For the informant, is an application under section 483 of BNSS paying for granting bail to the accused applicant in connection with Kolton Bazar Police Station case number 196/2026 under section 108 of BNS 2023. Call for the CD, let the matter be listed. Let the matter be
24th,
listed.
ma'am.
24th.
Obliged.
So the petitioner's wife, she died of an unnatural death.
Within
171 days he is behind the, within 7 years, no? He is behind the bars for 171 days. A charge sheet has been filed, my lord, and.
what is the stage now?
Stage, my lord, is fixed for evidence, my lord.
It's for evidence, okay.
the next date is on 18th
We'll
of
call for the TCR.
my lord.
We'll call for the TCR at this case.
And
Mr.
also
S.
the FSL report has not been enclosed, my lord. That has also not been provided. The FSL.
FSL report. FSL report not provided with the search.
Because the charge sheet says that FSL report.
Supplementary search sheet they have stated or what?
No, my lord, because that may also be called for, my lord.
Record will reveal everything.
Okay, we'll see. Heard Mr. S. Khaun, the learned counsel appearing for the accused applicant. Also heard Mr. MP Goswami, learned appeal for the state. It is an application under section 483 of BNSS, praying for granting bail to the accused applicant in connection with Duliajan Police Station case number 21/2026 under section 80 in bracket 2 of BNS 2023. Corresponding sessions case number 78/2023. Registered to call for the PCR in connection with sessions case number 78/2026 from which court?
Additional district session judge Dibrugarh.
Additional district and session judge Dibrugarh. Scan copy, no? PCR scan. Let the matter be listed on 25th.
Lord,
25th we have fixed lot.
so many cases, huh? 27, my lord.
27.
Lord.
27 August.
Lord.
Can it be on 28, my lord?
28, okay, 28.
Please, your lordship. Before taking to FIR, lordship, just I will know 28, lordship. Lordship. What is the cause of death? Lordship. As cause of death is aspirin pneumonia, immediate cause pneumonia, ensuing alcohol withdrawal seizure, manner of death natural. At page 20.
FIR.
FIR is a translated copy at 11, lordship, and vernacular copy at 18, lordship. Very good.
Call for the CD.
Behind you for last 30 days, lordship.
How many? 30 days.
30 days, lordship.
We call heard Mr. Esther Poddar, the learned counsel, appearing for the accused applicant. Also heard Mr. Antti Goswami, learned appeal for the state. This is an application under section 483 of BNSS 2023, praying for granting bail to the accused applicant in connection with Kajikam PS case number 27/2026 under section 103/117/2/3/5 of BNS. The list, call for the CD.
Along with PM report, lordship. If possible, PM report.
Charge sheet isn't filed, no?
No, that should not fail. That should not fail.
Call for the CD along with the PM report.
No.
Let the matter be listed 28.
28. Sorted if possible, lordship.
28.
No.
Regular bail application, lordship, offenses under section 103 of BNS. Lordship will have the FIR on page 13. I have been in custody for last 392 days, lordship, and trial has already commenced. If I may read.
What is the state of trial?
Lordship, 6 witnesses examined of 11 minutes.
Okay, we'll call for the PC.
Yes.
Heard Mr. A. Atria, the learned counsel, appearing for the accused applicant. Also heard Mr. MP Goswami, learned appeal for the state. This is an application under section
take it, you can accept them, but you take it.
praying for granting bail to the accused applicant in connection with Ampur PS case number 93/2025 registered under section 1031 of BNSS 2023. Corresponding in bracket you can write sessions type 1 case sessions in bracket type 1 case number 41/2026. Registered to call for the PCR, front copy of the PCR from
29, man.
from
Second date.
Registered to call for the TCR from the court of the learned additional district and session judge number 3, Naga. Let the matter be fixed on
29.
29.
Completely. May pleasure, Lord. On the last application, lordship was directed us to file an additional affidavit.
No, I have not directed. You wanted to file it.
No, but in this case, that rejection order of
Court will not direct, provided you ask for it.
But page 30 is the rejection order of the.
That is why you have not filed it. That's a mandatory thing.
Yes,
You
yes,
should file
madam.
it. That's why you filed an additional affidavit.
Yes, madam.
I have not directed.
Page 30, madam, is the rejection order.
Yes.
But this rejection order, madam, is in respect of the boy, madam. Now father is before your lordship, madam, and 47 days in custody.
The rejection was for the boy.
For the boy,
The father was not there.
No, madam.
Father has come now.
No, yes, madam. Father under bail, he is in custody, madam, father. And moreover, madam, at the time of the alleged incident, madam, the girl was 17 years, 10 months, some months, madam. Now, after attaining majority, madam, she, madam, came with the boy, madam, and madam, now they are living, and now, also, now she is above 18, madam. She came with the boy. Now they have applied for special marriage. They have made an agreement also. Now they are staying as husband and wife, madam. So, regarding father, madam, possibly, madam, boy, madam, his anticipatory bail was rejected, madam, but regarding the father, madam, possibly there may not be any further detention.
You are referring for whom?
For victim, I'm for victim.
Then
I filed an affidavit, Lordship. And page 20, Lordship, the marriage application acknowledgement. Lordship, now we are accused number 1 and I got married and living conjugal.
this is required. Heard Mr. S.M. Abdullah PV, the learned counsel appearing for the accused applicant. Also heard Mr. MP Goswami, the learned APP, as well as Mr.
K. Islam.
K. Islam, the learned counsel appearing for respondent number 2. This is an application under 483 of BNSS 2023 paying for granting bail to the accused applicant in connection with Holy PS case number 39/2026 under section 137 in the 2 of BNS, regulate section 4 at PROCEED Act with section 61 in the 2 of BNS and section 17 of PROCEED Act 2012. Then we can write. An FIR was lodged on 11/4/2026 by the informant in for Howley Police Station alleging entirely that his daughter, namely X, dated X aged 17 years and 10 months, was proposed by the accused applicant number 1. He was, I mean, his father was an applicant earlier time when it was rejected.
No, madam, the other I have anything. Oh. But he was applicant, madam, but
Who was number 2?
the number 2 is the father.
Then you are saying not applied.
No, madam, during the pendency of this,
No, I asked you specifically whether he applied for a bail
Yes,
or
I have
not.
an
You are saying no.
no, madam, page 29, madam.
Page 29, he's there.
Yes, madam.
That's why.
Yes.
Then you are saying no, he has not applied.
No, madam,
AB was there.
I'm so sorry, madam, but I couldn't understand. Madam. Actually, he was arrested during pendency of this AB, madam.
Okay, we accused applicant and is it? One second. No, just a minute. Okay, you're right. was proposed by the son of the accused applicant on several occasions for a relationship and harassed her mentally. But when the informing daughter refused the proposal, the son of the accused applicant started threatening her, semicolon, that on 26/3/2026 at around 3:30 p.m., while his daughter was returning from shopping from Pandakarpara market, on the advice of the accused applicant, his son forcibly hit her in a Maruti car, and after reaching at Howli Chariali, put her into a bus and took her to Gauhati, semicolon. That the accused applicant's son took the informant's daughter to a hotel room in Gauhati and committed rape on her. Semicolon, that on the next date, that is on 26/3/2026, the son of the accused applicant put his daughter on a bus and sent her to Howli. On receipt of the FIR, police registered Howli PS case number 29/3/2026 and the recommendation sections. The learned counsel appearing for the accused applicant submits that the accused applicant is not connected with the alleged offense as narrated in the FIR. He submits that accused applicant is the father of the father of the person who had allegedly took the minor daughter of the informant. He submits that during the in the meantime, the accused applicant was arrested on
On the 26th.
26/6/2026, and for the last 40 days.
47. For 47 days.
47 days, he is behind the bars. He He submits that the informants, the victim girl, had in fact resolved the issue with the son of the accused applicant, and both are now staying together after attainment of majority of the victim girl. In view of the aforesaid, he submits that since the girl and the boy are staying together, the accused applicant, the custody of the accused applicant may not be required. Mr. So and so is
Islam.
submits that the girl and the boy have already applied for registration of their marriage. And marriage. He referred to the acknowledgement slip which has been brought on record by way of an additional affidavit, filed by him. Full stop. After perusal of the acknowledgement slip, as well as taking into account of the submission made by the counsel appearing for the parties, this court is of the considered opinion that the accused applicant should be released from jail immediately on furnishing of the bail bond. Should be released from jail immediately. Accordingly, it is directed that the accused applicant shall be released on furnishing of a bail bond of ₹30,000 into security of like amount to the satisfaction of
Special just POCSO
forfeiture, subject to the condition that the accused applicant shall appear before the trial as and when required. In terms of the aforesaid direction, the instant bail application is disposed of.
Oblige, madam.
Your Lordship, kindly pass over the matter for the time being.
Also,
Please, your lordship. Herein the son and father is before your lordship. This 9 is the FIR. Case 9 is the FIR, Your Lordship.
As per FIR, allegation is against Town is
Number
there.
1.
Accused number 1. Right to rep.
Who is accused number
Two
two?
is the father, against him.
They are the accused number 2 and 3, Your Lordship.
Hmm?
Present petitioner.
There is no 2 and 3. There is only 2 applicants. Where is 3?
3, base 13, Your Lordship, kindly. Base 13.
No, I'm talking about the person before this court who has filed this.
Accused number 2 and 3, Your Lordship.
Accused number 2 and 3 in the FIR.
Yes.
Two is the
Where have you mentioned this? 2 and 3?
But I have only mentioned that, Your Lordship, whole allegation is against the FIR name accused number 1. And the present petitioner number 1, he is the brother of the accused number 1, and the 2 is the father of the accused number 1.
No. You tell me one thing. In the FIR,
Yes.
there are 3 persons' name were there. In translation, why have not you mentioned those? You take it back and come up with a proper translation. You take it back and come up with a proper translation.
But if
What but
I file
what
additional
but in the
evidence-
vernacular medium, in the vernacular distinct language FIR, this 3 persons' name were there. In translation, why not? It is not there.
For it, Your Lordship, I will file additional evidence.
Why it is not there? While translating, why you have not put those names there?
But in hearing,
Why you have
Yes,
not
there
put
is
those
mistake
names
there. I
there?
admit
Translation
that.
has to be correct.
I admit it. Lordship.
Translation has to be correct. You take it back and correct it and come back.
Then I'll file additional evidence, Your Lordship.
Don't do this kind of things. You translate it and
I admit it, Your
with
Lordship.
your, don't admit, with your own convenience, you will put something, and with your own convenience, you will not put something. Can it be done like this? Translation means what?
I understand, Your
You
Lordship.
leave certain portions from translation.
Yes.
This create confusion, madam.
But herein, Your Lordship, that.
Wait. You heard me, sir.
A.M. Khan.
A.M. Khan, the learning counsel, appearing to the accused applicants, also heard Mr. K.K. Parasad and an AP for the state. This is an application under section 482 of BNSS 2023, paying for granting 3 years bail to the accused applicants in connection with Finale PS case number 05/2026 under section 74/75/127 bracket 2/62/351 bracket 2/296/3 bracket 5 of BNS 2023. an FIR was lodged on 12/7/2026 by one Javed Ali, alleging that on 9/7/2026 at about 1 p.m. When his wife went out of home for cutting grass, the accused person came from behind and after Trump came from behind and after closing her mouth, took her to good cultivation with the intention of committing rape. It was alleged that when he went cry, the informant along with two other persons rescued his wife. It was alleged that when the informant along with others went to the house of the accused person, his family members, including the accused applicants, had abused them with filthy language and threatened to kill them. Full stop. Then the learned counsel appearing for the accused applicants believes that the accused applicants are not involved in the allegations as made in the FIR. Therefore, they were family members of the accused applicant. They are the family members of the accused person, namely Noor Islam. Noor Islam is
Yes.
who is the main accused?
Noor Hussain.
Hmm?
Noor Hussain is the main accused, Your Lordship.
Noor Hussain.
Yes.
But you have written Noor Islam here.
Noor Islam, the present petitioner, Your Lordship. Noor Islam and Samir Ali, Your Lordship.
Where were the cause? One Noor Islam nabbed my wife. Page 9.
But it will be Noor Hussain, Your Lordship.
Right, heard Mr. A.M. Khan, the learned counsel appearing for the accused applicant, also heard Mr. K.K. Parasar, learned APE for the state. Due to several discrepancies in the translation, the instant
Lordship,
AB
I may be
application,
allowed to
instant AB application is allowed to be withdrawn.
with
Allowed to
liberty.
be withdrawn. No, dismissed as withdrawn.
On withdrawal, Your Lordship.
Dismissed as withdrawn.
Okay.
Don't file this kind of petitions again. Don't file this kind of petition without looking into it. Yes.
This is accept the bail application, my lord. The application before lordship is a resident of Silchar. This is a resident of Silchar, my lord. Is a local businessman. The FIR was lodged by on page 17 is the FIR, my lord. It was a one Onokuma Desmok on behalf of his son. He has lodged the FIR, my lord. That you will also find at page 17, my lord. Sum and substance of FIR is that his son has parted a sum of rupees 13,80,000, my lord, way back in 2024, and they have received back 1 lakh and 12,80,000 still to be paid back. That is the contents of the FIR, basically. And since the payment was not forthcoming, my lord,
FIR was filed when?
FIR was filed in 2026, my lord.
8/7/26.
8/7/2026.
Incident happened when?
2024, my. Transactions were month of 24. Before lodging of the FIR, they filed one legal notice also for demanding the same amount. That is page 24 is the legal notice, my lord. That is 1/5/2026. And we submitted our reply also, that denying that allegation, my lord. And thereafter, what happened, my lord? The transactions were made in the name of one of firm, my lord. That your lord will find at page.
Name in the firm. Name of the firm.
Firm, my lord. That firm is a page 64, my lord. In the while filing application before the session judge, my lord, as Silchar anticipated, they raised objection, my lord. Then in objector that your lordship page 64 is the transactions were made in the name of one Pivotal International. They will start from 13/3/10/2024 to 26/11/24. That is admitted by them in a affidavit, my lord. And this farm is owned by one Pranjal Chaudhary, the son of the petitioner, who was arrested and granted bail, my lord. I am no way related with that sort farm is concerned, my lord. These are overseas payment made by the son of the informant. Son of the informant has paid this amount to Pivotal International, my lord. This is purely a civil dispute, my lord. And that too, Pivotal suppressing these facts, my lord, they lost the FIR. It would have been, nature of transaction has not been clearly stated in the FIR, my lord. You will look that it was made in the name of Pivotal International, owned by so and so, the son of them, who have been the cousin of the. This case, my wife also granted anticipation.
Yeah, I mean, this person, this Prasun Chaudhary is, Abhishek Deshmukh's brother-in-law.
Brother-in-law.
Huh?
Brother.
So Abhishek Deshmukh is basically, lazing these things.
Yes, my lord. He is the owner of the proprietorship farm, my lord. And
Who has been granted bail?
my wife, my lord. By this, my wife and son, session judge, my lord, page 53, my lord.
How wife is?
Wife.
How wife is linked?
Because his name in the FIR, my lord. That your lord, page 53 is the order, my lord.
Hmm?
Look, he is appearing for the informant, my lord.
On behalf of informant. Lordship, I have filed. On behalf of informant Anupama Deshmukh. Lordship, I have submitted my Wakalatnama. I may be allowed to start with one copy of bail application. I will find objection. And the Prasun Chaudhary is actually, he requested the Abhishek Deshmukh. Abhishek Tung, there in his son's company, there was some financial problem is going on. And so to lend a few amount, it's 13,80,000 amount. On the request of this Prasun Chaudhary, my informant, son of informant has credited this amount on the account of company Pivotal International, which was actually run by the son of the petitioner. And the informant, son of the informant was in Doha, so he could not come. So on behalf of the son, his mother has filed this FIR. So, Lordship, the Prasun Chaudhary, there are multiple cases going against the petitioner. One of the NIA, there are two NIA cases. One NIA case is on amount of 10 lakh another in is 98 lakh, and another two under Minimum Wages Act and CRK 603, 2015, and CRK 20518. In these cases, he was convicted. So he usually do these things. There are lots of instances where he cheated people. So he appeared people, requested people for money. Again, he did not pay back this amount to multiple people. And on the taking advantage, this Abhishek Deshmukh lives in Doha. So he somehow managed to pursue him and has taken money from him. And after taking all the money, he didn't pay back the money which money was
We
paid
will
back.
call for the CD in this case.
Considering the huge amount of money is
No,
involved.
your lordship will kindly see the objection, my lord. One line, my lord.
We'll call for the CD.
Let him go on
Heard
interim
Mr.
bail,
P.
my lord.
Kotoki.
It is a matter of 24, my 2024.
Correct, maybe.
And one thing, my lord,
Kotoki, the learned senior counsel, assisted by Mr. S.C. Biswas, the learned counsel, appearing for the accused applicant. Also heard Mr. K.K.
A.S.
Patel, learned APP for the state, as well as Mr.
A.S. Chaudhary.
A.S. Chaudhary, the learned counsel, appearing for the informant. It is an application under section 482 of BNSS 2023, playing for granting pre-arrest bail to the accused applicant in connection with Silchar PS case number 636/2026, corresponding to GR case number 1112/2026 under section 316 in bracket 2, stroke 318 bracket 4, stroke 336 bracket 3, stroke 340 bracket 2, stroke of BNS 2023. All for the CD, let the matter be fixed on when.
sorted maybe you.
Mr. Parasar, when?
September,
Let-
27th. From Silchar.
27th?
Because in their objection, my lord, they have categorically stated my wife is responsible.
No, wife, everyone requested for money. Everyone is involved in this.
27/8.
Let it be on 24th.
Man,
24. I'm giving a short date.
24.
24 hours.
If CD doesn't come, my lord, we are
24.
consider.
You can press it again then.
Because in the objection, my lord, they have claimed their wife is
Yeah,
responsible.
I have seen that. I have seen that. But there are the antecedents are not good.
And
Nowadays,
him?
in fact, you are supposed to disclose all the antecedents, not only connected with this case that you have not done. You see the latest Supreme Court case. Jeba versus state of, I forgot.
Yes.
There says that all antecedents,
But
not only related to this case,
I
you
understand,
need
but-
to disclose.
But so far as present case is
So
fine.
that is,
Involvement
that
may
is
not be
why,
there, my
I mean,
lord.
your antecedents are not good. So without perusing the CD, this court is not inclined at this case. Let the CD come.
Yes.
24.
Macho.
9. Wait, please, Your Lordship. Pre-arrest bail, my lord. Lordship will find, have a look at page 17, my lord. My lord, sir, complaint case was filed before the CDM court, my lord, and it was forwarded to the police to register a case, my lord.
Okay.
My lord, your lordship will see, my lord, the complainant Surafa Khatun and the accused Azizul Rahman, who is before your lordship. My lord, page 18, my lord.
1 second. Yes.
Lordship, seen the, my lord, complaint, my lord. Now, my lord, page 29, my lord.
Mm.
The charge sheet has been laid, my lord,
Mm.
where I have been shown as an absconder, my lord. Page 29, my lord.
Mm.
Below that, 10,
Mm.
serial number 10, name Azizul Rahman, shown as an absconder, my lord.
Mm.
Now, my lord, they got married, my lord, in the meantime, my lord.
Mm.
So I want to appear before the court, my lord, along with my wife, that is the informant, my lord, the next day.
You married by what?
my lord, I am married.
Is there any
And-
certificate of marriage?
Yes. No, no, this is an application filed before the my lord, the registrar.
No. Applied for him.
Applied. Third applied, my lord.
Applied for marriage.
And my lord, nowadays, my lord, for registration of marriage, my lord, one affidavit is also required. That I have also annexed, my lord, at page, my lord, 26, my lord.
Is it a POXO case?
No, no,
No.
no, no.
Allegation of rape is there.
Okay, we'll give him interim at this stage. We'll come back, whatever. Heard Mr. Anjay Dutta, the Learned Counsel, appearing for the accused applicant, also heard Mr. K.K. Parasa, Learned Review for the state. He is an application under section 482 of VNSS 2023, granting, praying for granting of DRS bill to the accused applicant in connection with PRC number 135/2026 pending 2026. Corresponding to the Banganga PS case number 291/2025 under section 64 in bracket 1/318 of BNS. By Learned Counsel appearing to the accused applicant. Then you write the allegations as alleged in the FIR dated 16/11/2025 or that under promise of marriage, the accused applicant has committed rape from the victim girl. This Learned Counsel, Mr. Anjay Dutta, appearing for the accused applicant, submits that after the incident, and after the investigation, police filed a charge sheet on 21/5/2026, and at present the matter is pending for evidence.
My lord, appearance, my lord.
The matter is pending for appearance. Pending for appearance. He submits that in the meantime, both the victims and the accused person has got married, has applied for, has been staying together and has applied for a registration of their marriage. He has submitted applied for marriage to stop. In view of the accusers, he submits that the accused applicant as well as his wife are willing to appear before the trial court and cooperate with the trial. In view of the accusers, he submits that the accused applicant should be granted PROCEEDINGS bail. Mr. Parasa, do you have anything to say?
Well, as well as both the person applied for marriage, both are major.
Your lordship pleases on the next day, my lord. We may appear personally in this court also.
Why?
Husband and wife.
No, not people. I mean, you just verify,
But
it is there. in the-
they may appear before the trial court, and
That would be the best option, my lord, directing both the husband and wife to appear before the trial court, my lord.
trial court.
Then we can dispose it off. Right?
Yes, but that's fine.
Dispose it. Taking into account, then you write this thing, this one line you write. The Learned Counsel appearing for the accused applicant has submitted the application for the registration of marriage, which is kept on record by marking X. Any date of appearance has been given?
18/8.
18/8.
18/8.
Okay. Taking into account the entire facts of the case, this court is of the considered opinion that the accused applicant should be granted PROCEEDINGS bail. Accordingly, it is directed that in the event of arrest of the accused applicant shall be released on promising of a bail bond of ₹30,000 security of recognition, subject to the condition that the accused applicant along with his wife appears before the trial court, that is SDCM Which court is this?
My
SDJ?
lord, SDGM. Sorry, my lord.
JMFC, first class, Bongaigaon. Bongaigaon on the date of appearance, that is on 18/8/2026. In terms of the aforesaid direction, the instant AV application is disposed of.
I'm obliged.
May I beg your lordship, this is 482 bail application lordship. Petitioner is not named accused lordship. The contents of the FIR is one Mujibur Rahman and Shahjahan Khandokar has stolen the telecommunication equipment lordship. That is radio remote unit lordship, which has used in 5G network lordship. And FIR is page number 8, operative portion is lordship, 10 lordship. What is lordship? Long FIR lordship. With due respect, I requested that 128/6/2026, a credible source of information was received regarding certain persons dealing in stolen telecommunication equipment in the Soigaon area, and they would be arriving with stolen telecommunication materials. Accordingly, the agency was not.
Two persons were arrested, Majibur Rahman and Shahjahan Khandokar.
But lordship,
Radio unit was recovered from them, and it's not a common man using material, it's using mobile tower.
yes.
Now, where is the apprehension of the petitioner? Why he is apprehending? There he has not mentioned. May kindly see para 4. The FIR doesn't disclose any allegation, either direct or indirect, against the petitioner. So why he is apprehending,
But lordship, 1/15/2026 and 28/2026,
Police-
investigation officer went to my residence lordship,
So-
to arrest me lordship.
so
But I am-
there is something is there, so CD is required,
Lordship. Some interim protection may be given, petitioner will appear before the investigation
You
authority.
dictate the order. You dictate the order. You take his dictation.
Sorry, lordship.
Mr. Parasar, there is no mention of him anywhere.
Yes, so where is his apprehension? Police visited him, house, maybe there is material in the city.
Just one, lordship, I am praying for some interim protection lordship. Petitioner will appear before the IO lordship. And a statement will be.
Otherwise, nowadays several this type of cases coming, remote radio unit. It is no use for common people, Malad. This is mostly used in the mobile towers for 5G and 4G network.
Heard Mr.
Alim Sheikh Lordship. A. Alim Sheikh Lordship.
A.
Alim Sheikh Lordship.
A. Alim Sheikh, the learned counsel appearing for the accused applicant, also heard Mr. K. PROCEED, learned PPP for the state. Is an application under section 482 of BNSS 2023, aimed for granting anticipatory bail in connection with Chaiga Police Station case number 127/2026 under section 303(2)/3(5) of BNS 2023. An FIR was lodged on 28/6/2026 by SI Dibyajyoti Rajbanshi, Choigaon, alleging that on receipt of credible information regarding certain persons dealing in storing telecommunication equipment in Choigaon area, the Choigaon area, and that they would be arriving with stolen telecommunication materials, a ZD entry was made on 28/6/2026, and thereafter, the police proceeded. The police thereafter police at about 7:30 p.m. while conducting surveillance near the embankment of river at number 7 Ghatpani, they noticed several persons carrying certain telecommunication materials, namely radio remote unit. It is alleged that on noticing the police party, they attempted to flee from the spot. However, after a chase, they successfully apprehended one person along with the said equipment, while the remaining persons managed to escape. On being questioned, the apprehended person disclosed his identity as Mujibur Rahman. It is stated that that in a few meter distance, it is stated that in a few meters distance, under suspicious circumstances, another person was arrested. His name is Shahjahan Kondakar. On receipt of the FIR, police registered Soigaon Police Station case number 127/2026 under the aforementioned sections. The accused number one was police station. The learned counsel appearing for the accused applicant submits that he has apprehension of arrest because police has visited his place twice, but could not find him out. On the other hand, the learned APP submits that he doesn't have any apprehension of arrest in the instant case, as his name has not been named neither in the FIR nor in the forwarding report. Full stop. He further submits that there is no mention of his name by any of the accused persons arrested. Also, therefore, there is no apprehension of his arrest in the instant case, and the instant case should be dismissed. Taking into account the materials that we should discuss and submission and hearing and on consideration of the submissions made by the learned counsel appearing for the respective parties, this court doesn't find any merit in the instant AD application, and accordingly, the instant AD application is dismissed. Yes, yes.
Lordship, this is an anticipatory bail application, Your Lordship. The petitioner before Your Lordship is senior citizen lady, Your Lordship. The complaint is at page 16, Your Lordship. Page 16.
Page 16.
Complaint. Lordship, my name is at 2, Your Lordship. President, accused number 2. May I read Your Lordship?
what is your case?
Lordship, in this case, Your Lordship, this is a society, Your Lordship.
The society, huge amount of money has
Money,
been
yes, Your Lordship.
misappropriated.
Lordship, I am the president, Your Lordship,
Yes.
and the treasurer, Your Lordship. He has been missing, Your Lordship, since 6/7/2026 with the amount, Your Lordship.
As per FIR, allegation is 10 crores.
10 crores, Your Lordship.
So, this is only case that you.
And the complainant, she suspects the involvement of the son-in-law of the treasurer, Your Lordship.
So, but you are the president. You'll have to take
The
some.
namesake, Your Lordship.
You'll have to take some responsibility. You are there in the executive committee.
Lordship,
You can't say that though I am a president, I don't have any responsibility. It is only the treasurer, he is responsible. You
Lordship,
can't say that.
Lordship, the
Can
annual
you say
meeting
that?
was on annual meeting was to be held on 8, Your Lordship, 8/7, and prior to that, on 6/7, she
I say huge amount is there,
A huge amount, Your
whether,
Lordship.
I mean,
even
no, now thing is that like where the money was kept.
Lordship, only 4,000, it's, they came to know 4,000. It was in the bank on Lordship, and the rest, it was in her custody, Your Lordship.
Okay.
She takes everything, Your Lordship. She maintains the book also.
No, correct. I mean, like if 10 crore rupees is there, you have not kept that money in the bank. I mean, like you have not tried to find out that
She does everything, Your Lordship.
she does everything, that is fine. But like, I mean,
That knowledge, Your Lordship.
but I mean,
Being registered from
that's an executive committee. There is a society, registered society. If society functions like this, 98% ladies are saying that their money has been taken away. I mean, how can you can say that I don't have any responsibility?
Even the president, she also deposits money, Your Lordship.
No, then I mean that kind of attitude. If you are having that kind of clumsiness, if you are having, then you should suffer from that.
Lordship,
We'll call for the CD, madam. We will be able to.
she has been cooperating with she has been cooperating
I
with
will call for the CD.
Lordship,
I mean,
in the meantime, I may be protected, Your Lordship, because earlier, Lordship,
no,
I might
this kind
submit, Your
of I mean attitude of a lady who is heading a society wherein 10 crores of public money fund has been deposited, and she says that no, I do not know anything because treasurer keeps everything. I mean, then she should not take this kind of position.
She was about
She
to.
should not take this kind of position.
Lordship,
This is a pure case of negligence. Negligence also, that too also a criminal nature. You can't say that like, I mean, I don't know anything about it. We'll call for the case diary.
yes,
madam.
Lordship, if I may submit, Lordship, the other two accused person, they have been guaranteed bail by this honorable.
Which court? Where is the order?
And the date has been fixed on 7/9.
Interim has been given.
Meantime, I may be protected. One is secretary and one is vice president.
Kavita Deka and Torulata Malak.
Gitali Mas is this thing, president.
President.
Yes, yeah.
Kavita Deka is the secretary and Torulata Malakar is the vice president. Number Gita Malak.
Okay, I mean, all executive members, one coordinate bench is already granted protection, so we are also protected. Okay, heard.
By the way, Caesar also has been made here.
Caesar, there is nothing, only 4,000 rupees.
Yes, sir, and the books and all registration, register and all. those.
Money is gone. What is to be
Yes,
done with those?
money is gone, Lordship. I admit your Lordship.
Anyways, heard MS MD Burwa, the learned counsel, preparing for the accused applicant. Also heard Mr. A.K. Parasar, learned EPP for the state. For the state, and FIR was lodged. No, this is an application under section 483. 482 of the NSS 2023. We are praying for granting pre-arrest bail to the accused applicant in connection with Concom police station case number 82/2026 dated 18/7/2026, registered under sections 316 in bracket 2 stroke 318 bracket 2 stroke 3 bracket 5 of BNS 2023. An FIR was lodged on 18/7/2026 alleging inter alia that the accused applicant wherein C is the president of Gauhati Nagar Mahila Samanvay Samstha Sadgaon. Semicolon that about 93 women members of the society used to deposit their respective amounts in the society. Also, it was alleged by the complainants that the son-in-law of the treasurer is involved in siphoning off the whole amount of about 10 crore rupees with connivance with the treasurer. It was also alleged that the other executive members of the society may be also involved in the Ali's misappropriation. On receipt of the FIR, police registered Kharkar police station case number 82/2026 under the aforementioned sections. The learned counsel of the accused applicant submits that she is a senior lady holding senior lady and is the president of the aforesaid society. However, she is not involved in maintaining the account of the society, and the same is being looked after by the treasurer, namely Srimati Pratima Das Negi. She submits that her involvement there is no specific allegations against her involvement in the case in the FIR. In view of the aforesaid, she should be given the privilege of pre-arrest bail. The learned APP on the other opposes the PR of bail, taking into account the interfacts of the case and the fact that the specific allegation has been made against the treasurer and the son-in-law of the treasurer and her son-in-law. This court is also considered opinion that some interim protection should be granted to the accused applicant. Accordingly, it is directed that in the event of arrest of the accused applicant, the shall be immediately released on bail and financing of bail bond of rupees 20,000 rupees with a security of like nature, subject to the satisfaction of the arresting authority. Subject to condition, subject to the satisfaction subject to the condition that the accused applicant shall appear before the investigating officer within a period of 10 days. 10 days. Appear before the
10 days, yes, Your Lord.
within a period of 10 days and shall fully cooperate with the investigation. Interim periods, all for the series. Let the matter be fixed on
Fixed on 7/9, my lord, along with
7/9 along with AB
AB 175526 and 177426.
17 AB number 1774 stroke 2026 and 1755 2026 on 7/9 na?
7/9.
On 7/9 on 7/9.
Much obliged.
Please, Your Lordship, 482 indemnity bail application, FIR at page 7, translated copy, Lordship. Page 7.
Yes.
Lordship, FIR was filed on 1/8, Lordship, and the LS incident occurred on 27, Lordship. After 11 days, she filed this FIR. She is Major 22, and there was a established, Lordship, the love relationship was there, and in 3 sections are implicated, Lordship. 351, that is available, 64 and 78, rape and
Love relationship was there. From where are you saying love relationship?
Lordship. Annexed to I have annexed, Lordship, some photographs, Lordship, that will show you, Lordship, that there was a consensual relationship, and the allegation come out after, Lordship, broken up of their relationship. After 11 days, Lordship, she filed this FIR. Allegation of 27/2026, and she filed this on 1/8/2026, Lordship. Just to show you, Lordship, that the relationship was consensual, I have annexed some photographs, Lordship, nothing else. So I may be protected. I am ready to cooperate in the investigation, Lordship, and 3D may be called for.
Photographs will not say anything, Malat. Maybe dear Malat, but CD may be called for. Her statement is required, Malat.
I am ready to cooperate, Lordship. Can you protect me?
Why should I protect you?
Lordship, because rape and stalking does not attract me, Lordship. There was consensual relationship, Lordship, and after 11 days, she filed this affair after broken up of the relation, Lordship. After when the relationship becomes so, Lordship, this kind of allegation nowadays come, Lordship. That's why, Lordship, I'm begging for protection, Lordship.
Word, Mr.
J.S. Ahmed.
J.S. Ahmed, and counsel appearing for the accused applicant. Also heard Mr. K.K. Parasol and AP for the state. APP for the state. This is an application under section 482 of BNSS 2023. Praying for granting an anticipatory bail to the accused applicant in connection with the ICOM PS case number 116/2026 under section 351(2) stroke 64 wicket 1 stroke 78 of BNS call for a CD. Let the matter be fixed on. No protection. Let the matter be fixed on.
Short date, Lordship. 21, Lordship.
28.
20.
20.
20.
Okay.
Obliged, Lordship.
We'll see the CD, then we'll see what is to be done. So we'll come back in 5 minutes.
Malat.
Number one is the Lordship, brother of the husband of Alice victim, Lordship. There is brother-in-law of the Alice victim, woman, Lordship.
You said number 1 is the brother.
Number 1 is the brother-in-law of the Alice victim, Lordship. And 2 is the father-in-law, Lordship.
Brother-in-law and father-in-law.
Father-in-law of the Alice victim woman, Lordship.
Father-in-law and brother-in-law, both.
Yes, Lordship. Father-in-law and brother-in-law. And the petitioner number 1 is only FIR named, Lordship, whose name is not there, but police search him, Lordship. Will Lordship may kindly peruse FIR at page 11, Lordship.
Petitioner, brother-in-law is named. Brother-in-law is named in the.
Brother-in-law is named here, Lordship. Petition number 1. Only, Lordship, the father-in-law of the son of the petition number 2, Lordship, lost the instant.
My allegation is assault with sharp weapon in and causing head injury. Medical report is required with CD. Accused assaulted my daughter with sharp weapon, causing injury on her head, back, and hand.
Heard Mr.
Any problem?
NH Borgio, the learned counsel, according to the accused applicant, also heard Mr. PK Tawasa and agree for the state. There is an application under section 482 of BNSS to paying for granting 2 years bail to the accused applicants in connection with Boginodi PS case number 70/2026 under section 118/2/296. Stroke 351 of BNS 2023. Call for the CD with the matter.
25th.
25th.
My lord, petition number 2 may kindly be protected. His no allegation was.
No.
He is only father.
No. Let's call for the CD.
Well, 54, a report was called for whether any cases registered or not. Malad, we have a written report. Malad, at Samoguri PS, Malad, there is no case registered against Indo Soikia. Malad, one GDNT was there, but no case registered anyway.
You withdraw?
Maybe close, Malad. Maybe close.
These are open by the council for the accused applicant, also have the security person one of the for the state. This is an application under section 483 of BNSS TV paying for granting 2 years bail to the accused applicant. Currently, in Samagri police station is in connection with some in connection
435.
with Samagri police station. Wherein the
Report may be kept on record.
apprehended that the case has been filed against the accused applicant. A report was called for. On 6/8/2026 by a coordinate bench as to whether any case has been filed against the accused applicant in Samagri police station. Stop. Accordingly, a report dated
Last line, Malad.
report dated 2012/8/2026 has been received from the concerned police station, that is Samagri police station, and it is seen that no case has been filed against the accused applicant in Samagri police station. In Samagri police station against the accused applicant. In view of the episode, in view of the aforesaid, the instant the application is closed as dismissed.
Obliged.
In a very peculiar circumstance, I approach this honorable court. And your lordship will find FIR at my lord, base 18, my lord. I am working in the research assistant in transport department. And this FIR was lodged, your lordship, and it's page 18, my lord.
Yes, now
Para, no offense is made out anyway, my lord. Para 5, your lordship can see of the FIR, my lord. It's an administrative lapse, that's why,
Yes,
my lord.
yes.
That is why, lord. And two persons who are dealing assistant and one of the minor comment placed pilot person, they were arrested and they were produced before the court below my lord, and very same day granted bail on the ground that my lord, only here the section involved, only one section is non-bailable, that is 316 my lord 2. But there is no ingredient of 3162, that's why granted bail in very same day, my lord. So I am also, my lord, one of the, my lord, such assistant. I was called for the police station and I went there, my statement has been recorded. And I was not arrested, I was statement recorded. Now again, they might, sometimes they call me. That's why, because apprehension of that, my lord, I approached this honorable court. I am a very young man, last 2 years ago, I have joined the assistant. So your lordship kindly see, while granting bail by the court below, arrested, same day produced and granted bail on the ground that, my lord, there is no page, my lord, your lordship state, I have annexed that order, my lord. Page 41, my lord. That is the only section is, my lord, non-bailable. But entrustment of property is where there, my lord. Criminal bishops, that there must be entrustment of property, my lord.
Ellen Cookie or Ratul Sharma? Ellen Cookie, Ratul Sharma, I don't know.
Yes. Page 41, last part, my lord. Page 41. Prima facie, the material on record not disclosed in essential ingredient of criminal bishop trust and complainant on section 3162 of the PNS. There is no allegation of entrustment of property and accused persons are nor any allegation dishonest or misappropriation of the conversation property of so. So accordingly, they were bail was granted in the very same. So that is my share. I am even not naming it and not dealing with my dispute.
Yes, Mr. Aforesaid.
Otherwise, not let the city come in the meantime, my lord.
City required in this case.
Just to, my lord, avoid the contempt case, this has done.
Lord Mr. T.J. Mahanta, the Lord Senior Counsel, assisted by Sir also Mr. K.K. Parasol, and APE for the state, is in application under section 482 of BNSS, paying for granted PRS bill to the accused applicant in connection with CID-PS case number 01/026 under section 61 / 1998/223/255/216 in bracket 2 of BNS 2023. The gist of the facts, is that on 26/2/2026, one Vikram Dev Sharma, ACS Secretary to the Government of Assam, pursuant to personal laws then affair before the Special Director General of Police, CID, Assam, releasing inter alia that Honorable Gauhati High Court, while its common judgment and order dated 26/2025 in WA number 14/2022 and connected matters had directed the reinstatement reinstatement in respect of the affected officers within the stipulated period. The phrase discharge order issued in respect of Srimati Suranjita Hazarika was never served upon her. It was further alleged that Transport Department issued a phrase discharge order by notification dated 11/7/2025 along with corrigendum dated 21/7/2025 in compliance with the Honorable Court's directions. However, due to non-service of the said order, the aforesaid Suranjita Hazarika approached the Honorable Gauhati High Court by filing contempt case number 33 contempt case in bracket C number 33 of 2026 alleging willful disobedience of the judgment. It was stated that the Honorable Court by interim order dated 18/2/2026 directed the respondents to permit her to join service within 30 days. It was alleged that the circumstances surrounding the non-service of the discharge order disclosed serious administrative lapses and that the possibility of criminal conspiracy, a connivance among the government employees to deliberately ensure non-service of the order could not be ruled out. In terms of the aforesaid FIR, the CID PS case number 01/2026 under section, under the aforementioned sections has been registered. The learned senior counsel appearing for the accused applicant submits that there is no allegation. There is no specific allegation against him. However, the accused applicant is also serving in the department as a research scholar. What as what dealing? Huh?
Research assistant.
Research assistant.
Transport department.
Research assistant in the transport department. Transport department. He submits that two other persons working in the same department have been arrested, and they had been produced before the learned.
Order.
Learned court of the chief learned court of the chief judicial, learned court of the CJM Kamrup Metro, and they have been already granted.
On 18th.
And they had been already granted bail.
Granted bail to the other two persons.
The granted bail, full stop. The learned senior counsel submits that there is no ingredient of section 316 involved. 316, which is a non-bailable offense, is present in the instant case. He submits that the accused applicant has already appeared before the investigating officer, and his statement has already been recorded. He submits that in view of the aforesaid, the custodial detention of the accused applicant may not be required in the instant case. The learned APP, Mr. K.K. Parasar, on the other hand, submits that the case diary should be called for and the case should be considered on perusal of the case diary. Taking into account the submissions made by the learned counsel appearing for the respective parties and going through the materials brought before this court is of the considered opinion that the accused applicant should be given the privilege of pre-arrest bail. Accordingly, it is directed that in the event of arrest of the accused applicant by the investigating authority, he shall be released on bail on promising of bail bond of ₹30,000, which is with the security of like nature to the satisfaction of the arresting authority, subject to the conditions that the accused applicant shall. You have already appeared.
Yes, my lord.
Is there any notice? Notice again given to you? No notice has been given to you.
Not yet.
You will cooperate, my lord.
Shall cooperate with the investigation and make himself available as and when called for by the investigating authority. In terms of the aforesaid direction, the instant AV application is disposed of as allowed.
Develop.
Watching regular bail application, petitioner before lordship, they are in custody since 7/7. 7/7/2026, 35 days.
How many days?
My lord,
How many days?
35 days.
35.
My learned friend from the FSL report is not there.
FSL report not received yet, my lord.
It's case of fake currency.
Fake currency is my lord.
Fake currency.
My lord.
LSD recovered from the premises of the petitioner.
Okay, then we'll wait for that.
My lord.
I heard Mr. P. Hazarika, learned counsel for the accused applicants, also heard Mr. B. Sharma, learned APP for the state. Though the case diary has been received, the FSL report is not available. Call for the FSL report and let the matter be listed on.
My lord. August কিমান তাৰিখে হ'ব আপোনাৰ কনভেনিয়েন্ট হ'ব 27 না 27th August.
Let the matter be fixed on 27th August.
Public.
Lordship, we have filed the wakalatnama today. We'll file our objection.
None appeared.
And we need
none
the
appeared-
copy also, Lordship.
None appeared for the accused applicant when the matter was called for, though MS Beta, the learned forms. You are appearing for? Respond number 2?
Yes, Lordship. Yes, Lordship.
Amicus or what?
No, Lordship.
Mitala is present for respondent number 2. She submits that she, she submits that she has filed a wakalat number only wakalat number today only, and requires some time to file an objection in the matter. Full stop. Let the matter be listed. On
Lordship, copy may be
let the matter be
served to
listed.
us.
We have received notice.
We have received notice,
You
but
didn't-
we
you
have
didn't get the
no copy.
24th August, the learned council. You're referring?
Yes.
And Islam?
Yes.
Copy to Marquis, this thing. And Mr. An Islam, the learned council, is to serve the copy of the bail application during the course of the day to the council appearing for the respondent number 2.
Much of.
May Lord. My lord, as per the order, my lord, this matter, my lord, CD as well as the PM report was formed, my lord. So I have inferred,
My lord, not PM report received, my lord.
Hmm?
PM report not received, my lord.
Why PM report is not coming?
My lord, here.
May fix it,
Okay, heard Mr. S.
Fine.
Das, the learned counsel appearing for the accused applicant, also heard Mr. D. Sharma, learned AP for the
Fine.
state. PM report is not available. Let the matter be listed on 25th.
My lord, 28, my, 28, my lord.
28.
highly obvious.
26.
Maybe so much. Regular bill application. Was arrested on 25/7. In the past of the past 20 days.
Hmm?
Past 20 days. The
Last
FIR
20 days.
Yes, FIR the page 17.
CDS come.
CD received, my lord.
The allegation is that I was carrying, caught while carrying fake gold, 2 bricks. Page 17. In the first line itself, madam.
Page 17.
Yes, madam. On 24/7/26 at around 10:45 AM, credible information was received from a reliable source and so on and so on. I was apprehended on 24/7/2026.
Hmm.
At around 11 AM, madam.
Hmm.
However, madam, the arrest memo, madam, that's a page 38, madam. Page 39, madam, serial number 3, madam. It shows that I was arrested on 25/7 at 10:30 AM, madam. There's a discrepancy there, madam. And a report was called for from the Chief Judicial Magistrate Navjoli, madam. That just flagged, my lord.
What are you saying? What are you saying?
Lord, I was apprehended on 24/7/26, my lord, at around 11 AM. However, I was shown as arrested on 25/7, my lord, at around 10:30 AM, my lord, to make up for the time for the production of Planet Court, my lord. The report was called from the CTA Madhuli, my lord, that is that flag A, my lord. That says that I was produced on 25/7/2026 at 4:30 PM, my lord. So that is beyond 24 hours, my lord. Since I was apprehended around 11 AM on 24/7, my lord. And the seizure list, my lord, that is here, my lord.
Yes, yes. See you in the second.
That shows seizure was effected on 24/7 at 1:48 PM, my lord. Even that
Okay.
time is taken, my lord.
I don't know.
It is beyond 24 hours, my lord.
Yes.
Yes, what is this?
The Caesar list, my lord, that time is taken, my lord. Caesar was effective at 1:48 PM, my lord, on 24/7/26 from the position of the accused petitioner, my lord. Even that time is taken, my lord, production was 3 hours later, my lord, from the 24-hour period. My lord.
My lord, here we have received the case there, my lord. From the case there, it reveals that, my lord, within the 24 hours, he was produced before the.
How
my
it
lord.
is, how it is calculated is so.
My lord, it is here, my lord. It is here. How, and that was, my lord, here, my lord, time. And thereafter, my lord, Caesar witness also it was proved, my lord.
Hmm?
That Caesar witness also proved that at 1:45, some documents, it was seized from the accused person, my lord. That's my kindly please. Time is there, my lord.
Where is this place? Gormore PS.
My lord, Gormur, my lord.
Gormore PS to which CGM he was taken?
CGM Majuli.
GM, huh?
Majuli.
Imagine.
The Gormore to Mazuli,
It
how
is
far?
around 15-20 kilometers as per Google.
Hmm.
Lordship sees the arrest memo, my lord.
Yes, yes. At 4:45, formal FIR lodged, my lord.
4:45 PM.
4:45 PM, my lord.
The fire was lost.
My lord.
You were saying before production at what time? Before
Production was at, my lord, 4:30 PM on 25/7/26.
from where are you saying so?
That flag A, my lord. In the report call from the CGM Majuli, my lord, flag A, my lord.
Hmm.
I think it's in the first paragraph, my lord.
Who has called for this? This
The
thing?
court, my lord.
Hmm?
The court was the call for the report.
Which code? This code?
That last order, my lord, T8, my lord.
The CD says something else.
My lord.
Yes, my lord, but the FI itself is clear, my lord.
The CD says something
My
else.
lord.
The FI itself is clear, my lord, 24/7.
What FIR? FIR clear is what? What is clear by the
Yes,
FIR?
my lord, page 17, my lord.
Now what you read?
That 24/7/2026 at around 10:45 AM,
Hmm.
credible information was received, so and so, my lord.
Hmm.
Accordingly, Naka checking operation was conducted at Select Hungary, so and so, my lord.
Hmm.
One Activa scooty bearing registration number so and so coming from Dhunaragi Ghat side was signaled to stop at the
You
checking
tried
point.
to, you tried to flee away
My lord.
from the spot. Then you were chased. Then you have been caught.
Yes, my lord, but then
The-
my lord, the Caesar list, my lord.
Hmm?
The Caesar list, my lord.
No, then Caesar list.
Caesar
What?
list,
1:45 a.m.
My lord.
1:45 PM. my lord.
1:45 p.m. You are produced before the court at 2 p.m.
No, my lord, on 25/7, I was.
25/7, 2 p.m. You are produced. So
No, my lord, the report says so.
no, it says CD says so. It's recorded in the CD.
No, that is, I think it's possibly not correct, my lord, because on
It says it says that now I produce the arrested accused person. The order may have been passed a little bit later on, but he was produced at 2 o'clock. That is the CD says.
possibly that is not correct, no.
CD is incorrect.
Possibly, my lord, because.
I'll go by with your this thing. The
No,
order was passed here, maybe a
Page
little later on.
39, my lord, people see, my lord. Arrest number, my lord, even the time of arrest is wrong, my lord. Date of arrest is also wrong, possibly, my lord. Page 39, my lord.
Page 39.
Point number 3, my lord.
Hmm?
The arrest number, my lord, point number 3, page 39, my lord.
Hmm.
What you say date and time of arrest 25/7/26 at 10:30 AM. That is, they have shown the formal arrest of the accused petitioner, my lord. But I was in their custody since the day before, my lord. And Lordship will see, my lord, point number 5, my lord. Whether the arrested person forcibly resisted the endeavor to arrest him.
No, I mean, arrest memo may be something wrong. We'll go by the CD, no? What is there in the CD?
Possibly not correct, my lord. My humble submission is that, my lord. I was apprehended around 11 AM, my lord, on 24/7, my lord, as per the FIR itself. During the Naka checking itself, I was apprehended, my lord. Subsequently, Caesar was affected 1:48 PM, my lord. Even if that time is taken, my lord, it is beyond 24 hours. Possibly.
I mean, he has been arrested on the previous date.
My lord, he was apprehended, my lord. Thereafter, he was.
So apprehended means what?
My lord, thereafter, my lord, some recovered, some, my lord, that.
I mean, you have, I mean, you have
Thereafter, my lord,
the
he was
timing wrong.
medically examined. Thereafter, my lord, he was formally lost the FIR, my lord. That is, CD reveals, my lord.
Your people are very relaxed. They have luxury of time. So they take, I mean, these things very easily. So that is why this conviction rate in Assam is so something. The difference is something around about 70% with the national rate. We will pass the order in this case. I'll just go through the CD once.
The thing, my lord, the sections attributed here, my lord, are the new matlab 420-406 matlab. Here matlab what has happened? I was caught while carrying suspected fake gold matlab. Had I delivered the fake gold matlab, and possibly the sections would be applicable. Yeah, possibly matlab. I was not caught while handing it over to.
You have not done anything.
My lord,
Your client hasn't done anything.
my lord, gold boats
Yes,
were
but
recovered from his
carrying
possession,
fake
my
gold
lord.
matlab, there is possibly no legal
Your
offense,
client
my
has not done anything,
My
Mr. Mahajan.
No, I beg my pardon, Lord Bossman.
We'll pass the order.
My lord.
I'm highly obliged. Obliged.
58, 59, 360. Milord will kindly have a look at the Milord recording of the proceeding, Milord.
How many bail? 3 or 4?
Total 4, my lord, but one person is other.
My lord will kindly have a look at this. Now regarding suppression part, Milord. And my learned friend will rely upon a notification that also I'll answer. New things we are learning. Column আছে না নাই? And in fact, Milord, my prayer was not for absolute bail. My prayer was for interim and calling for the CD. It was Honorable Court who has given it, Milord.
It has been mentioned about this.
Not only mentioned, I placed those 2 orders, and my prayer was based on those 2 orders.
That is there, Mr. Borua.
Therefore, my prayer is, Milord, Lordship will close this item number bail app AB 865 of 2026 and Milord 866 of 2026 and 1583 of 26.
13?
Milord,
1583.
865 of 26 and 1583 of 26 by one Siraj Ali and AB 866 of 26 by Deepak Kolita and another. In view of the order passed in 1707 and 1706.
My lord, may please, my lord.
1 second, just.
Yes.
Yes.
Lordship may kindly take up, my lord, the anticipated bail application number 1707, my lord.
Yes, I'm taking this.
1707, my lord. And Lordship may kindly peruse, my lord, paragraph 7 of the bail application, my lord.
Paragraph 7.
7, my lord.
Yes. Okay.
So, my lord, after reading this, my lord, if this honorable court thinks, my lord, there is no suppression of material facts, my lord, then I have nothing more to submit, my lord. Then Lordship may kindly also peruse, my lord, the order dated 27/7.
No, let us see what was the order passed in Shiraz Ali. Shiraz Ali,
Yes.
Shiraz Ali in 865.
865, my lord, that Lordship will find, my lord.
That order was passed on 34/2026.
Yes, yes, my lord, first order. My lord.
34/2026, he was protected.
Protected.
Hmm.
No coercive measure.
No coercive measure. He was protected.
My lord, my lord, the last portion I am reading, my lord. Hearing the submission made by the learned counsel for the parties, all other aspect of the case, the learned additional PP is hereby directed to call for a report from the Polasbury police station, my lord.
Correct.
That is, my lord, in respect of only one police station, that is Polasbury police station, my lord. As to whether any case has been registered against the petitioner in the said police station or not. And in the meantime, till receipt of such report or till receipt of case diary, my lord.
Correct. So in this case, there is no suppression.
My lord,
And
no.
in 865, there is no
No, my lord.
suppression.
No.
Then in other case,
There is one more, 1583.
1583.
Yes.
Yes.
1583 was
Taken by because the department, my lord, filed a complaint. Cooperative department.
In this case, my lord, the interim protection, my lord, no coercive action by order dated 21/7, my lord. 21/7/2026, my lord.
21/7. That is also prior to that other one, no?
Yes, my lord.
Other one. So
Prior to the third one, my lord.
correct. So in these cases, there was no suppression. Or
No
what?
suppression, but my lord, that is my humble submission, my lord. If Lordship peruse the order dated 27/7/2026 passed in both the cases, my lord.
2020?
27/7/2026, my lord.
21/7.
27, my lord. 27 July, my lord.
In which case? I mean,
In my lord,
1583.
AB 1583, that is a common order, my lord, and AB 865.
No, 1583, the order of 21 only.
No,
21/7.
27/7, my lord.
Yes, 21/7 is the order.
21/7.
21/7 is the order, my lord, by which, my lord, he was granted no coercive action, my lord.
So where is the 27 order?
The 27 order, Lordship will find, my lord.
27 or 20?
27, my lord.
277. Okay.
Yes.
Submits the urgency in the matter. It is
The last portion, Lordship may say CDB retained, my lord.
CDB retained.
Yes, my lord. That means, my lord, while this matter was taken up on 27/7/2026, my lord, a junior friend appeared, my lord, and we have apprised the court that there is some urgency CD received, my lord. So court has directed to retain the CD and fix the matter, my lord, on 5/8/2026, my lord. Thereafter, my lord, 1707 was, my lord, moved, and they have obtained, my lord, obtained absolute order, my lord, by suppressing material facts, my lord.
Your only thing is that, see, thing is that you'll have to see the intention also. One thing is that like these two bail applications, he has been protected.
Yes.
Correct.
Yes.
He has been protected. It's not that his bail is rejected.
My lord.
It's they have been protected.
Protected, and that was continuing, my lord.
That is continuing. They're protected. They were continuing. Then they have filed this other one that
1707.
1707.
My lord.
And your only thing is that in 1707 there was no mention made about these two applications.
My lord.
Applications.
My lord.
I mean, in the body of the application, there is no, pleading as such.
No pleading as such, my lord. And in spite of the fact that, my lord, case was already been registered, my lord, in which case they have obtained the absolute order, my lord, and case that was already in this court, my lord. Case that was already available.
Case that is already there. I'm trying to understand one thing. What benefit he will get or how he will be like benefited
How is
by
stand to gain?
or how you will be prejudiced
No, my lord.
by these two orders.
We do not want any benefit, my lord, out of any order, my lord.
No,
We
I'm
want, my
asking,
lord-
no, I'm asking you, so you are opposing it, so that's what I'm asking. I'm trying to understand actually. That if these two applications they have filed, they have been given protection.
My lord,
The interim protection was given.
my lord.
And you are saying that maybe it's true also that like they have not mentioned about these two, then moving of these two applications and the subsequent orders passed in these two applications in this 1707.
My lord.
Now there is a circular or notification from
Yes.
the High Court that
Yes.
everything has to be disclosed.
Yes, ma'am.
That is your concern that like why this has
No,
been done.
regarding 1707, my lord, we have already taken appropriate steps, my lord.
Correct. So
Yes,
that has
regarding that, my lord, I am not on, my lord, regarding 170, because
No,
that
no,
bail application has already been disposed of, my lord. So we have to, my lord, if we go for a cancellation of bail, my lord, we have to approach the higher authority,
correct.
my lord.
Now what remains now?
But regarding the, my lord, these two pending applications, let the notice be issued, my lord. Under what circumstances, my lord, he has filed another bail application, my lord. In connection with the same offense, same police station, my
You
lord.
said there is no case pending against him. Report was
My
called
lord,
for.
report was called for because while no course of action was issued, my lord, while the order was issued,
No, now
but
tell
no
me
course of
one
action,
thing.
my
Now
lord.
tell me
Then
one-
report
no, no.
was, we
Now
were
tell
asked
me
to,
one thing. He wants to withdraw these applications.
my lord, withdraw when, my lord? After obtaining the favorable order, my lord. After obtaining the absolute bail application, then they are withdrawing, my lord, today, my lord.
What will be the point of keeping these two applications
No,
pending?
my lord. Let the notice be issued, my lord. To
No,
the
why
petitioner, my lord.
court should issue notice?
Notice to whom?
Whom to and says
Notice to petitioner, my lord. Under what
File-
circumstances, my lord, he has been under.
Petition, don't make oral prayer. File a petition, there is a procedure. You are taking too much
no,
of
see,
time
this
just for nothing.
court
Just
has
to satisfy your ego.
already made one bail application absolute.
My lord.
After hearing you, after CD was, I mean, I don't know whether CD was seen or not.
No.
But anyways, it was a order was passed.
Sir, my
Now
learned friend
these
is
two-
making really unreasonable
No,
prayer.
now
my lord.
these two
This
applications-
such prayer should be rejected outright.
Keeping these two applications
I have also
pending,
put in 40 years of practice. I have not
what
heard such
purpose will
arguments.
be served?
My lord, my humble submission, my lord, they have even, my lord, if they have withdrawn the, my lord, these two applications on
No,
27/7,
see, had it been a case that like in these two cases their bails have been rejected, then they have procured this bail, bail without disclosing this, then it would have been different thing. And in the argument also they have placed this about mentioned
that's
about
right.
this.
my lord, my submission is that, my lord, why, my lord, they were already protected by this honorable court, my lord. In
So he
connection
will
of,
decide-
It was not protected.
So he will decide whether
my
a
lord,
file a
no
petition or not.
no coursive action means, my lord, what, my lord?
No coercive action, but like report was called for.
Yes, but
Then Polasbury PS case was, they found that Polasbury PS case was filed. So they moved this application.
Yes.
then, my lord, other cases, my lord, if suppose, my lord, tomorrow, can police arrest him, my lord? If when the police station.
These two orders will go, I mean,
Yes.
when did you withdraw this?
My lord, these two order will go after obtaining the third order, my lord. Otherwise, these two order was very much in my lord, valid, my lord.
I don't know what you are submitting. I'm not understanding anything what you're saying.
And my lord, it is my petition. I want to withdraw, my lord. Lordship should not hear such public prosecutors who are wasting the court's time.
No, my
Let us be very
submission,
clear about
may be recorded, my lord. Lordship may pass any order, my lord.
Yes.
My submission may be recorded. my
You
lord.
give your submission in writing.
Yes.
I could not, because I could not understand your
Yes.
submission.
Yes.
You give your submission in writing.
No, my humble submission
No,
is
you
that,
give
my-
your submission in writing because
Yes.
I could not understand anything what you're
Then
saying.
Lordship may
I
fix
could
it.
not understand anything what you're saying.
Then Lordship may fix it after a week, my lord.
Not after a week. Now you will give it after 2 hours.
Hello, my friend is
I mean, I'll pass the orders.
yes, deeply.
You give it in writing. What submission is to be recorded. I'll record everything in detail.
My lord.
Yes.
But the date 13th day, and my lord, going to the.
Sorry, my lord, CD not yet
35
received.
days, my lord.
1 second.
CD not yet received, my lord.
My lord, kindly see the FIR, my lord, in the section under which case was registered. Allegation is, my lord, but NOC was obtained by one Amjad Ali. And Amjad Ali says that, my lord, that was given by me and by some other person. Co-accused statements. Now, section you lost kindly see, and we work against the government. That is the only section by which life, otherwise 60 days is statutory period of time. Page 13.
So you are Mr.
I am Ali,
You are
number
Ali
2.
Jinnah.
Number 2.
Ali
Ekis number
Jinnah.
2 মানে
Actually, number 2 more in the FIR.
So NOC was granted with taking money.
No, to money to Amjad Hussain. Amjad says that matter that was given by the previous person. This is the case. You are on the co-accused statement. 35 days minor in jail matter. Further custody required. I am only on that matter. Yes, your lawsuit will decide was as your lawsuit may be impeachment. In section kindly say matter 148. How it comes.
Yes, what is
Malat,
that?
Malat in page 21, the earlier could be rejected the bail. Malat, Malat may see the Malat last
20?
last line. Page 21, Malat.
Page 21.
Last 3 lines. Upon calling Amjad Hussain to the office, he disclosed the FIR name accused person Farooq Sheikh and Ali Jinnah had supplied 4 NOC instead of original after accepting 57,000 from him. Yes, they told that the NOC was the original and genuine. Now, Malat, this type of incident, Malat, happening, Malat, the government record has been Malat manipulated, Malat, affecting government record, Malat, and revenue, Malat. So this is Malat short date, Malat. Next week, Malat. Next Tuesday, Malat. If not, then Malat.
You have not. You don't have the CD.
No, CD is not available.
CD, then we'll wait for something.
I only thought the section you also have seen.
That I've seen, but let us see the CD. I mean, I don't think like more custodial detention may be required. Let us see the CD.
18, my lord.
But let us see the CD.
Actually, you lawsuit. I think he.
No, I mean, see, I mean, there are allegations. Allegations are serious.
Yes,
Allegations are serious. Only thing is that like whether his custodial detention is required or not. That we'll see, and we'll see the CD what is there, and then we'll pass an order. For his HRS and his senior counsel assisted by so.
15 August before 15 difficult, Malab 18 Malab.
18 and also her Mr. CD is not received. Later matter is fixed on. Later matter is fixed on 18th. 18th.
No, 18. Very urgent Malab.
Okay.
No. I mean Monday I am hetu karna ek din agot lo.
Morning, so the matter should be adjourned for a week.
The prayer of the Lord Council.
22 to 28 August. In between 22 to 28 August.
Wait. What the prayer of the your name?
Farhana Iqbal.
Item number 16.
16. P. Chaudhary, on behalf of P. Chaudhary.
You are for the respondent.
Yes.
You have intimated the other side.
Yes, sir.
Whom did you intimate?
P. Chaudhary, my senior.
No. Have you intimated the other side, counsel?
Sir, that my seniors knows. Actually, she informed me just now. So.
Okay, on the prayer of the learned counsel, appearing for the respondent number 2, let the matter be listed on 28. Wait.
May I please, your lordship? Lordship, on the consent of the other side, lordship, I beg to mention item number 13, lordship. Kindly matter may be adjourned.
Why didn't you mention in the morning? It is not time for mention. Item number, which item?
Item 13, Lordship.
13 on the prayer of the learned council appearing for the, you are for the petitioner.
Yes, Lord.
Petitioner let the matter be listed after 2 weeks.
Yes, please.
এখন দিব স্যার এখন দিব
Petitioner is behind bar for 33 days, your lordship. Yeah, FIR, your lordship, will take it at page 21. your lordship. May I read, your lordship?
Yes.
Name and address of the complainant, Doyanto Doloi and Khonindra Doimare. Respected sir, with due honor and humble submission, we being the shareholders of Bordeaux Down Consult Sommelier Limited, we would like to inform you following two lines for the information on necessary action. Let's see, Aditya Ratha, the petitioner, so and so. Being the chairman of board where GPCSS Limited has opened a mini bank without following the guideline of RBI as per rules of society registration of Dr. Assam, and accordingly under his guidance, mini bank has collected money unauthorized from the general public near to Greater Bagan area. Collected money has not deposited in the proper account of mini bank. There is by misusing the public money by Sri Gauhati, and even they have not returned the public money in spite of several requests by the depositors. Moreover, he has collected the passbook issued to general public on the plea to return their deposited money, but he has neither refunded or deposited the amount nor even returned the passbook collected by him to general public. The CHC Aditya Rao has received block financial grant amounting to so and so in the name of Bordeaux GPCS Limited for the establishment of banana fiber under PD G48 2023-24, but he has not submitted any utilization certificate. Thereby dishonestly expenses entire money for his personal gain. That he has obtained a bank loan amounting to 55 lakhs so and so from Assam Cooperative FX Bank Limited, Vijayanagar in the name of Bordeaux GPSS Limited, but he has not deposited the said amount in the account of Bordeaux GPSS. Therefore, fraudulently misappropriately entire money for his personal gain. Based on this affair, he was arrested, your lordship, and behind bar for 33 days. My first submission will be, your lordship, that further custodial detention probably is not required. So far as the petitioner is concerned, your lordship, thoroughly interrogated. And so far as these allegations are concerned, your lordship may kindly come to page 7, para 10. I have explained. Your lordship. May I read, your lordship? Para 10. That the petitioner beg to state that on 2/10/2019, your lordship will kindly look at the date. On the occasion of Gandhi Jayanti, a financial institution named Sanjoy Nidhi was established in presence of Register of Cooperative Societies, Anupama Chakraborty and Deputy Registrar Nilotpal Gohai and the branch manager of Apex Bank, Vijayanagar. It is to be stated herein that from that time until the present, a total 1,415 recurring deposit accounts have been opened in the savings fund. Further, out of 1,415, 1,380 account holders have been paid back their principal amount along with interest. The remaining 35 account holders are currently being refunded varying amounts. Gradually, loans provided to farmers and businessmen from the Sanjoy Nidhi is so and so. 95 borrowers, 38 borrowers, loan outstanding, total loan amount receivable this much. Then para 11, that the petitioner beg to state that Bordeaux Gaon Panchat Sombai Samiti Limited received amount of rupees 8,11,000 on 21/3/2024 under the Assam government SOPDG scheme for establishing banana fiber unit. It is to be stated herein that under the said scheme, in departmental supervision and training trip to Madurai, Tamil Nadu was undertaken on 11/5/2023 and return on 15/5/2023, and again with departmental permission, a trip to Jorhat was made for training under the said scheme. Furthermore, for the third time under this scheme, the department arranged for training to be conducted in Gwalpara. Be it stated herein that
total 1,50,000 was departmentally approved out of the total sanction amount for the above 3 training programs. That the petitioner beg to state that after training period had completed, 4 cooperative societies joined together to form a federation committee consisting of Bordwar, Choigaon, Pantan, Luki GPSS, and Vijayalakshmi Trading and Marketing Cooperative Society. And banana fiber machine was purchased by collecting rupees 2 lakh from each cooperative. The Bordwar Gaon Panchayat Samiti Limited paid the said 2 lakh in 2 installments, so and so and so and so. That the petitioner begs to state that after procurement of the banana fiber machine and the production started, the Federation Committee observed that it was incurring more losses than profits out of the said machine. After due consultation, the department requested the committee to return the remaining sanction amount back, and accordingly on 25/5/2026, first installment of 2,30,000 was returned to the department via bank RTGS. It is to be stated herein that committee used the remaining 2,31,000 from the sanction amount to procure rice, which I thought that the remaining amount will be returned to the said department as sought for by adjusting it monthly grant, which the committee received from government generally within 28th and 30th every month. However, the committee received the monthly grant from government only on 10/7/2026, thus could not return the remaining 2,31,000 when sought by the department. It is to be stated that committee immediately after receiving the grant was ready to pay the remaining sanction amount back to the department. However, it was refused, stating that now already an FIR has been filed in relation to the said issue. The committee is ready to repay the remaining amount of so and so to the department. The Border Gaon Panchayat Committee, which the petitioner is the chairman, has always been. This is not important than para 14 or say. That the petitioner begs to state that this is the most important. Border Gaon Panchayat Committee has received Kisan credit card loan of rupees 55 lakhs 4,428, which was approved on 14/3/2020 to a total of 103 beneficiaries. It is pertinent to mention herein that as every beneficiary can withdraw the loan amount credited to them via ATM, thus the loan amount is not credited to the account of the committee. However, it is the responsibility of the committee to recover the loan amount, and the said committee has carried out its duty and recovered a loan amount of rupees 11,50,000 from the beneficiaries and deposited it to the Apex Bank, Vijayanagar branch, as per the mentioned below. These are the dates on which this was deposited, Your Lordship. Then the petitioner begged to state that after the recovery of 11,50,000, further recovery from the beneficiaries could not be carried out due to advent of COVID-19 pandemic, which halted the loan repayment process. Subsequently, the government of Assam and the Honorable Chief Minister had announced relief in loan repayment due to lockdown. Thus, all the beneficiaries are not repaying the loan amount as due to the pandemic. Due to beneficiaries suffered from several financial crises, due to which committee has been unable to recover the remaining loan amount from the beneficiaries. However, due to non-payment of the loan amounts, the accounts of the beneficiaries have been blocked, and several beneficiaries have raised concern before the committee that due to account block, some loan amounts have got freezed in their account, which they have not been able to utilize. The said was raised before the concerned bank by the committee, and it was asserted by the bank that the amount will be adjusted during pending repayment of loan. It is to be stated in the committee received neither any loan amount from the bank nor from the beneficiaries. Thus, the question of misusing the government fund by the petitioner does not arise. Now, these are the explanations. Your Lordship will kindly note one aspect. This is a registered cooperative society governed by the Cooperative Societies Act. There is a governing body, Your Lordship, consisting of 15 members. I am only the chairman. Now, Your Lordship, entire Your Lordship has been done, even assuming that something has been done by the committee, Your Lordship. Now, only one member, I was, Your Lordship, targeted and arrested in this case, Your Lordship. Although there is specific material, and interestingly, Your Lordship, to my instruction, till date, they have not investigated or not make any investigation in the committee's office, Your Lordship. No document has been seized till date. That is what my instruction is, Your Lordship, subject to, of course, correction, Your Lordship. Now, in the process, Your Lordship, the account is, Your Lordship, money is deposited in the cooperative society's account. Money it is not, I am not the only authority who is the signing authority. Secretary is also there. Board resolution will be required. And interestingly, Your Lordship, under section 35 of the Cooperative Societies Act, there is a power of the authority to inquire into the allegations, Your Lordship. They have not gone there also, Your Lordship.
But your lordship, they have lost this FIR, your lordship, and ultimately I was arrested. The reason for my arrest is different, your lordship. That in that particular area, border, your lordship has seen the name. I am leading a movement against the satellite township. It has been going on for long. And to suppress my voice, your lordship, this FIR has come suddenly, your lordship. This is going on. This is my humble submission, your lordship. Even otherwise also, your lordship, 33 days behind bar. Probably in my humble submission, further custodial detention is not required.
Yes, we have received the CD lordship, and that is CD lordship. And as per CD lordship, and the first lordship thing is that lordship, they have no right to collect the money as per the Society's Registration Act. That there is at the last, I have taken the last lordship. That is the report collected from the Society's Registration Office lordship, and where it is mentioned lordship, they could not collect the money. So collection of money is illegal, lordship. So lordship, when the collection of money is illegal, lordship, then lordship, this person has collected the money, and everyone, there are some witnesses, lordship, and the victims, lordship, who has stated, lordship, that these we have deposited, we have given money to Aditya Rava. So he has been collecting the money. So he is insisting the other people to invest on on them, and he is insisting as he is insisting. That is why his name has come up, lordship, in the light, lordship. And this is not that one more person, lordship. Everyone has so many persons has invested, lordship. 75,000, 75,000, 75,000 rupees, lordship. And someone has so several lakhs of rupees, lordship, they have collected, lordship. So lordship, collection of money from the public, that too in illegal way, which is not authorized, unauthorized, lordship, and subsequently that is not being refunded to the person when they have asked them to return it. So lordship, this is a crime, lordship. This is not he is not doing anything, lordship. And when he is insisting, so definitely his name will come in front, lordship, others, lordship. Others people are not insisting. Even his statement is also there, lordship. Lordship may kindly go.
Money is deposited where?
To he, as per the witness statement, we have deposited with him, lordship. That is they have given to them, lordship.
With him means?
In the society they have invested, lordship, but lordship, at the instance of him, lordship.
I have disclosed everything.
Collection of money, subsequently some beneficiaries have not returned the money. That is their problem, lordship. And
if they find something in my bank account that some disproportionate wealth, then matter would be different. Of course, your lordship, that would be given by the case that your lordship. Otherwise, your lordship, I have been thoroughly interrogated, your lordship, and no one from the cooperative society has still been arrested or your lordship interrogated, your lordship. And these decisions, even assuming they are, your lordship, these are collective decisions, your lordship. I am only part of that. If your lordship, that amount of 55 lakhs.
The only thing is that he's saying that like, without any authorization,
No,
because
your lordship,
RBI authorization is required.
that is what I am submitting. That this sonsoinogy was established in presence of Register of Cooperative Society. Specific affirmance I have made, your lordship. And I am only a president, Your Lordship. It's a collective decision, Your Lordship. And whatever it is, Your Lordship, ultimately they have interrogated me, Your Lordship, behind bar for 33 days.
The last thing, Lordship, can we go to that is the Lordship, a report from the society's day.
And I am cooperative society, Your Lordship, not the registered under Societies Act, Your Lordship. We are registered under Cooperative Societies Act. It's a constitutional body's 5-year elections are held in every 5 years.
But you are running a mini bank, whether you can run a mini bank.
No, that is, Your Lordship. For that, why only I will be responsible?
But that's a different thing. I
Your
mean,
Lordship,
whether
that's what, Your Lordship.
some other people maybe also, I mean.
And Your Lordship, I have not hide anything, Your Lordship. In para 10, I have disclosed everything, Your Lordship. Had there been a denial that I am not doing that, Your Lordship, then matter would have been different. I have mentioned here, Your Lordship.
But in your statement, you have admitted everything.
That, Your Lordship, admitted, I don't know, Your Lordship. I am not privy to that, Your Lordship. But, Your Lordship, further custodial detention for that is required or not, Your Lordship. That aspect, Your Lordship, will kindly consider, Your Lordship. And even if I have admitted, then investigation is complete, Your Lordship. No further investigation to be carried out, Your Lordship. They will file charges and I will face the music, Your Lordship.
Lordship, because Lordship, all the witnesses are not being yet recorded, Lordship. There are some witnesses are yet to be recorded, Lordship. And apart from that, Lordship.
That you can do, keep on doing. That you
Because
can
Lordship,
keep
if
on
he is come out, then tampering of witnesses are also there, Lordship.
See, the first thing is that this was done in presence of the government officials. Right? All these, I mean, aspects have been done. Presence means with consent. It has been done. Now, maybe there are some technical snacks were there that I do not know, but with the length and the detention, I don't think he should be required to be kept. You can investigate and like file a search. What Mr. As Waterco Learned Senior Counsel, assisted by Mr. Sorenso. Also have Mr. P.S. Lacko, the Learned APD for the state. There is an application under 483 of BNSS 2023 praying for granting bail to the accused applicant in connection with Polasbury Police Station case number 160/2026, registered under section 316 in bracket 5/318 bracket 4 of the BNS 2023. An FI was lodged by the complainants, namely Jayanto Doloi and Khanindra Doimari, alleging that the accused applicant, while serving as the chairman of Bodwar Gaon Panchayat Samabay Committee Limited, illegally established and operated a mini bank without following the prescribed guidelines and unlawfully collected deposits from the members of the public. It is alleged that we failed to deposit the collected money in the bank, in the account of the mini bank, misappropriated public deposits, and neither refunded the deposited amounts nor returned the passbooks collected from the depositors. It was also alleged that certain government grant was received in the name of the aforesaid Samiti, amounting to rupees 8,11,000, and the same was also misutilized by the accused applicant. Without submitting any requisite utilization certificate to the authority. It was also alleged that that the committee in the behest of the accused applicant obtained a loan of rupees 55 lakhs 4,428 from the Assam Cooperative Banks Limited in the name of the committee. However, the same money was also misappropriated by the accused applicant. It is alleged that instead of depositing or utilizing the same money for the society, the accused applicant has used the same for his own purpose. On receipt of the FIR, police registered Polasbari Police Station case number 160/2026. The learned senior counsel appearing for the accused applicant submits that the accused applicant is the chairman of the committee. And all the decisions whatever has been taken as per the norms of the society, of the names of the society, as the society has a board which it has a board. Society has a board which is the supreme body of the society and takes a collective decision. Therefore, he submits that individually the accused applicant hasn't taken any decision, and all the allegations about misappropriation of money is incorrect. He has referred to his explanation made in paragraph 10, 11, and 12 of the bail application, wherein he has detailed about the expenditure and utilization of money by the committee, by the aforesaid committee. He further submits that the accused applicant has already been behind the bars for last 32 days, and therefore further custodial detention in the instant case may not be required, as the case involves documentary evidence, and all such documents are available in the office of the committee. He submits that the investigating authority is he submits on instructions that the investigation authority is yet to visit the committee for further investigation. In view of the aforesaid, he raised that the accused applicant should be granted bail. CD in the instant cases has been received and sent is perused. The learned PS Capital, learned APP opposes the bail application, saying that the money has been collected unauthorizedly without any authorization from the authority, from the concerned authority. This court has heard the submissions made by the counsel according to the respective parties. It is seen that where is that when, I mean, before the authority that you have opened it, you made some statement here. Statement.
There are 10 euros. Page 7.
It is seen that it is seen that on the occasion of Gandhi Jayanti, a financial institution named Sansai Nidhi. So Sansai Nidhi is within the society.
In the society.
Sansai Nidhi was established in presence of the Register of Cooperative Societies and the officials of Apex Bank Vijayanagar. It is also seen that several recurring bank deposit accounts have been opened for collection and transaction of the accounts, details of which are available in paragraph 10. It is also seen that certain amounts. It is also seen that majority of the amount out of the money received from the government as sanction has already been released, already been returned by the committee. It is also It is also seen from the records that investigation in the matter has already also proceeded. Already, investigation in the matter has already almost been completed with the statements of witnesses have already been recorded. Taking into account this long detention of 33 days, 32 days behind the bars and other materials available in the case diary, this court is of the considered opinion that the accused applicant considered opinion that further detention of the accused applicant shall not be required in the instant case. Accordingly, it is directed that the accused applicant shall be released on bail immediately on furnishing the bail bond of rupees 50,000 with a security of like amount to the satisfaction of which
CGM Kamrup are
CGM Kamrup are subject to the condition that the accused applicant shall cooperate with the investigation and shall not try to tamper or hamper with any evidence whatsoever. In terms of the aforesaid directions, the instant DA application is disclosed of. The CD to be returned.
So here we have not received the CD, so Lordship, another this may be fixed. We have not received the CD, Lordship.
CD is yet to be received. Let the matter be listed after.
Palas by Lordship, sorted may be given.
Let them be listed on 19th.
Lordship. What is that?
Wait, please. The PRS bail application, my lord. FIR is at page number 26.
56.
32.
Anticipated bail.
Okay.
But the facts are like this, my lord. Page number 26, that is the FIR. So that one truck, my lord, bearing registration number WB33B, carrying a jute consignment, my lord, from Sorbok to Calcutta, went missing, my lord. And the owner of the consignment, my lord, lodged an FIR. Subsequently, my lord, he came to know that the same truck, my lord, using a different registration number, was again loading jute consignment at Dhubri, Gauripur, my lord. Thereafter, my lord, he lost his FIR, my lord, and this, my lord, truck along with the consignment was recovered. And from the truck, my lord, the original consignment notes were also recovered. From there, he came to know that the trucks were same, using two separate registration numbers, my lord. Subsequently, this FIR came to be lodged, my lord. And
You are the owner.
I'm the owner.
He is the owner.
The petitioner, my lord, is the owner, my lord, and he is from West Bengal, my lord. And the thing is, my lord, the day-to-day activities of the truck, my lord, is delegated to one Jamilur Rahman, my lord. Thereafter, my lord, the petitioner approached this honorable court, my lord. He was granted interim. He approached, my lord, and on the same time, my lord, he also prayed for Jimma. Jimma was also granted. Your lords will kindly have a look at the Jimma order.
Mr. Goswami, I don't
Yes.
think there is any requirement
Yes.
of him. He is appeared, he let him.
Lordship.
Heard Mr. S. Das, the learned counsel appearing for the accused applicant, also heard Mr. MP Sharma, the learned APP for the state, in an application under section 482 of BNSS 2023, praying.
Only thing, my lord, he's from West Bengal, certain COTs may be given.
In connection with Sorbuk PS case number 44/3026 under section 3/5/6/3/316/3/318/2 of BNS 2023. The basic allegation is that, I mean, you have been using, I mean, different registration numbers.
Yes, but three registration numbers,
So
my lord.
different.
One
The-
original, two fake.
Two fake, my lord. And it is suspected that he is also involved, my lord,
Against the accused applicant is
as per the
that
CD.
he has been using his truck for several trips with using different registration numbers, full stop. The registration numbers. The coordinate bench of this court by the order with the 10-6-2026 has granted interim pre-arrest bail to the accused applicant with the direction to the accused applicant to appear before the investigating officer given 10 days full stop. The learned counsel appearing for the accused applicant submits that in terms of the accused direction with the 10-6-2026, the accused applicant has already appeared before the investigating officer and his statement has already been recorded. He has also submitted that Jimma of the vehicle which was seized by the police has already been given to him. In view of the opposite learned counsel submits that his interim pre-arrest bail should be made absolute. The learned case that in the instant case has been resisted and the same is perused. The learned APP opposes the prayer of bail of the accused applicant. Taking into account the entire facts of the case and the facts of the case and the fact that he has already appeared before the investigating officer, recording his statement, this court is of the considered view that the accused applicant should be granted pre-arrest bail. Accordingly, the interim pre-arrest bail granted on 10-6-2026 is hereby made absolute. In terms of the opposite direction, the instant review application is disposed of.
He has given the COTs, my lord. Regarding bail conditions, COTs may be given, my lord, local COT.
It already, I think that has been given there in the interim order. already.
Lordship,
I'm not
Same-
modifying that
same
order.
conditions, my lord, same conditions.
Please, your lordship. I'm gonna say the 8 is the FIR, my lord. Here allegation is that my daughter-in-law has killed the mother-in-law, my lord, while mother-in-law is sleeping, my lord, by slitting her, my lord, neck, my lord. This is the allegation, my lord. But my lord, as she has from the my lord, forwarding report, my lord, it seems that there's a line, my lord, she has confessed also that while her mother-in-law was sleeping, my lord, she has my lord, with a blade, my lord, she has with her, my lord, mother-in-law. But it is a confession before the police, my lord. Lordship knows it is not admissible. And apart from that, my lord, yeah, admittedly, there were quarrels, my lord, between the mother-in-law and the daughter-in-law.
How many days you were there?
More than a month, my lord.
32 days.
More than a month, my lord.
At this stage, Mr. Palvi, it will be difficult. Let the investigation come to some kind of a conclusion. Heard Mr. Abdullah Palvi, the learned counsel, SM Abdullah Palvi, the learned counsel appearing to the accused applicant, also heard Mr. P.S. Lockhart, APV for the state, is an application under section 483 of the BNS 2023, paying for granting bail to the accused applicant in connection with Haju PS case number 311/2026 under section 103 in bracket 1 of BNS 2023. The allegation as made in the FIR dated 11/7/2026 is that the accused applicant.
5890.
Accused applicant is the sister-in-law of the informant and C. And C, after the marriage, started subjecting mental and physical torture on the mother-in-law as well as on her. It was alleged that about 2 months ago, it was alleged that about 2 months ago, the accused applicant physically assaulted her husband. So it is thus. It is thus. and the same was informed to the concerned police. It is alleged that despite this, the on the night of 10/7/2026, the accused applicant taking advantage of the absence of her husband, stabbed her mother-in-law, that is the informant's mother, on her neck with a sharp weapon, causing her death. On receipt of the FIR, police registered Hajab Police Station case number 319/2026 under section 103 in bracket 1 of BNS 2023. What is your submission?
Well, my submission is
Should I record anything?
Not even record, that I'm staying on the length of detention,
Detention is how much?
32 days.
Okay, the learned
And
counsel.
another thing, but I have not never absconded, my lord.
Okay.
I was there itself, my lord.
The learned counsel appearing for the accused applicant submits that the accused applicant is already
If I have
behind the
done
bars,
something, I have never absconded.
behind the bars for how many?
32 days.
32 days, and the accused applicant is a lady and is willing to cooperate with the investigation. In view of the aforesaid, the accused applicant should be granted bail. CD in the instant case has been received and the same is perused. Mr. P.S. Lockwood, the lawyer APG, opposes the bill, prayer of bail, submitting that there are apparent materials against the accused applicant of her involvement in the crime. This court has considered the materials available in the CD as well as heard the submissions made by the counsel appearing to the respective parties. In consideration, this court is not inclined to grant any bail to the accused applicant at this stage. Accordingly, the instant bail application is rejected. CD to be returned.
Rejected at this stage.
At this stage.
I'm obliged, my lord.
In item 57, Lordship, CS submitted, Lordship.
You go and appear. Heard Mr. K.K. Henrik, the learned counsel appearing for the accused applicant. Also heard Mr. P.S. Lockwood, the learned APG for the state. Is an application under section 43 of BNSS. Paying for granted bail to the accused persons in connection, accused applicants in connection with Bhagrapal PS case number 44/2026 under section 61 in bracket 2, bracket small a, stroke 126, bracket 2, stroke 117, bracket 2, stroke 109, bracket 1, stroke 309, bracket 6, stroke 62 of BNS 2023. What are the allegations?
Allegations are regarding lordship, criminal conspiracy, wrongful restraint, voluntarily causing grievous harm.
He injured someone over.
Yes, yes. Authorizing case number 15.
Allegations against the accused applicants is that they attacked the informed. Allegation against the accused applicants is allegation against the accused applicant is that while going by the national highway, the accused applicants confronted the informant and assaulted him brutally. The learned APP, Mr. P.S. Lockwood has submitted that charge sheet in the instant case has been filed by charge sheet number.
CS number, Lordship, 58/26, dated 25/7/26.
In view of the official submission, the learned counsel appearing for the accused applicants submits that he should be allowed to appear before the jurisdictional court for appropriate relief. In view of the official, the instant the application is disposed of the liberty to the accused applicant to approach the jurisdictional court for appropriate relief if so advised.
33, we have not received the CD lordship. He is on interim lordship.
The CD yet to be received, let the matter be listed on 28th August
28.
20. Interim orders of past earlier shall continue till the next date of listing. Yes.
Here also we have not received the CD lordship.
Also, already 3 dates has been given. 3 dates has been given already before.
He has
The 4th day.
2 days already given.
Yes.
Your name?
JM Das.
Game Das. We'll give some more time.
Last option. Last.
Heard Mr. J.M. Das, the learned counsel, appearing for the accused applicant, also having the appeals
Governor Prime.
for the state. CD is yet to be received, let the matter be listed on
21st lordship or 24th.
21st, 20th,
28th.
20.
Declare.
35.
We did not cut. We did not. 36 minutes.
It has come.
CS submitted also.
You go there. What Mr. What is your name?
A Islam.
What Mr. A Islam, the learned counsel, appearing for the accused applicant, also heard Mr. E.S. Lackard, learned appeal for the state. There is an application under section 482 BNSS praying for bail to the accused applicant in connection with Chapel PS case number case for 2026 under section 331 in bracket 4 stroke 305 of BNS. BNS corresponding to GR number 251 stroke 2026 at Chapel district to be assigned. The allegations in the FIR dated 10/5/2026 is that about stealing of allegation against the accused applicant is stealing of cows, stealing of soft cows. The learned counsel, learned APP submits the charge sheet in the instant cases already been filed by charge sheet number.
CS number lordship 81/26 dated 7/7/26.
बाकी की नहीं अपील हुई हाँ अपील को वो करने ये जिसमें कोर्ट सेम ऑर्डर है सेम ऑर्डर ठीक है बाकी नहीं की
37.
7.
Your BP is fine. Yesterday somebody told your BP was fluctuating. You also
sometimes
you are fluctuating your looks. That's why probably.
No, actually, I had a offside goal, so I had to ask for a review of that goal. Only when the goal was disallowed, then my pressure came into normal.
Okay. Okay.
Well, in this case, in terms of your lordship's order, we appeared before the investigating authority. Similar type of cases are registered all over Assam. And
Yesterday
this-
also lordship was disposed of my lord in the mill minor.
This rice mill case,
Okay, that case.
Yeah.
Okay,
similar,
let him go. Heard Mr. Mr. B.D. Kwon, Allied Senior Counsel, assisted by
Miss H.
so and so, appearing for the accused applicant. Also heard Mr. B. Sharma, the Allied APP for the state. This is an application of BNSS, paying for pre-arrest bail. Various bail by the accused in connection with Howley Police Station case number 108/2026 under section 318/4/316/6 P61/2 of BNS 2023. The allegation against the petitioner is that the petitioner was involved in alleged irregularities by rice mill in milling government procured paddy under Borpeta district. In Borpeta district also. The learned this court, a coordinate bench of this court, right order with the 15/7/2026 has granted interim PRS bail to the accused applicant with a direction to the accused applicant to appear before the investigating officer within a week. Full stop. The learned senior counsel submits that in terms of the aforesaid direction with the direction in order with the 15/7/2026, the accused applicant has already appeared before the investigating officer and his statement has been recorded. Full stop. Therefore, submits that the interim PRS bail granted to the accused applicant should be made absolute. CD in the instant case has been received and it is seen that the accused applicant has already appeared before the IO. Taking into account that aforesaid, the interim PRS bail granted by order with the 15/7/2026 is made absolute and the instant AB application is disposed of.
In terms of the order, when I leave the jurisdiction of my mill, I had to take the permission of the CZM property. I took once. I'm a resident of Gauhati and my business is there. So that condition, my lord, your lordship may kindly say that as and when required before the investigating officer, I will appear. Because I had to take the permission. I took once permission from the CZM to come to Gauhati. My family and all is there. Condition number 4. Your lordship, make it a state.
Then you are taking into account the prayer made by the learned senior counsel as counsel as far as the condition, bail condition, PRS bail condition number 4 mentioned in the order dated 15/7/2026 is
Your lordship may make it state. The petitioner shall not leave the jurisdiction of the state.
is modified. It is modified. Is modified to the modified to the following effect. Right, the petitioner shall not leave the jurisdiction of the state without permission of the jurisdictional magistrate. Yeah, that will do. It will provide one other. We have to have another.
May it please, Your Lord. Okay, we kindly have a look at the FIR page number 15.
No. My lord, IO has paid for another debt, my lord. He is on leave, my lord. Today CD not received, my lord.
Petitioner otherwise happens to be the father of the main accused. Father of the main.
IO paid for my lord another debt, my lord.
Let us see what is there.
Page number 15.
Let the CD come.
My lord, 103.
Mr. S. Das, Learned Counsel, technical case applicant, also have Mr. B. Sharma. CD yet to be received, let the matter be listed on
My lord, 24th, my lord.
24.
Hello.
49.
May it please, Your Lordship. My lord, in this case, my lord, the petitioner was granted interim bail with certain conditions which have complied with.
Okay, this matter, I mean, let him go. I mean, nothing is.
My lord, charge sheet submitted here, my lord.
Charge is submitted.
Charge sheet submitted.
He shall appear before the.
To appear before the.
My lord.
Heard Mr. Ahmed Learned Counsel appearing for the accused applicant, also heard Mr. B. Sharma, Learned APP for the state, based on application number 6482 of BNSS 2023. Praying for granting PRS bail to the accused applicant in connection with Ramya PS case number 119/2026 under sections 289/106 of BNS. An FIR came to be lodged on 15/5/2026 by one Karinda Kolita alleging materially that his father was working in a sawmill and while discharging his duties on 15/5/2026 at about 5:30 p.m. met with an accident allegedly due to the fault of the machine as a result of which he sustained previous injuries. It is alleged that he was immediately taken to the Swasti hospital for treatment where he succumbed to his injuries. And then a court, then you write, by an order dated 22/7/2026, the accused applicant was granted interim PRS bail by this court, full stop. The learned counsel appearing for the accused applicant submits that in terms of the aforesaid direction, in order with the 22/7/2026, the accused applicant has already appeared before the investigating officer and he is cooperating with the investigation. Full stop. The learned APP submits that in the meantime, charge sheet in the instant case has been-
Charge sheet number 200 of 26 dated 9/8/26.
In view of the aforesaid, the instant AV application is disposed of with a direction to the accused applicant to appear before the jurisdictional trial court within a period of 15 days, and till his appearance, the interim order passed on 22/7/2026 to be extended, stands extended.
Right.
Stands extended. In terms of the aforesaid direction, the instant AV application is disposed of. 15 days you appear there.
Yes.
Much for.
14.
My lord, there is CD not received, my lord.
Page 10 is the affair, your lordship.
Hmm?
Page 10 is the affair, petitioner is the government.
CD not received.
CD not received, my lord.
There is your lordship. Page 10 is the affair, he's a government servant. For last 4 years,
Last 4 years, he's avoiding arrest.
no,
Hmm.
last 4 years, he's by giving threat for physical relation with the informant, your lordship. Informant is a widow, your lordship. Page 10 is the affair. And petitioner is a government servant, he's a vaccinator. Yeah, that is correct. Last 4
My lord, 109 is also there, my lord. And here in the last part, it was said that, my lord, মোক বুকুত খুচি মাৰি আৰু প্ৰাণ নাশ কৰিলে মোক পুৰিল
the informant.
ফালে টানি চুচৰাই লৈ দিয়ে but what that is my lord. Particular, my
The
lord.
informant entered in the house of the petitioner. Pressurized to solemnize marriage by informants. Petitioner family did not accept.
So what do you want to say? That like only because of 4 years relationship you have,
Hmm.
that you will do something, anything?
Concerning party. It
The
shows that
consenting
it was-
party is fine, but what about the allegations of
He can-
hurting her, injuring her?
Very honestly, she entered into my house.
Let us see the CD. Let's
Right.
wait for the
Shortly,
CD.
because he is a government.
Heard Mr. S. Islam, the learning counsel for the accused applicant, also heard Mr. B. Sharma, learned APE for the state. CD is yet to be received, then it will be listed on
Government servant.
21st.
My lord.
Okay.
Fourteen.
So photo में लगा दो, well, even not later.
This
Yes.
is filed for quashing the complaint case, which was filed against me, my lord.
Who is appearing for the taxes?
Still pending
Lordship.
before the-
Huh?
This is
J. Chopra, lordship.
J. Chopra.
I was kindly case 22, my lord, the share case now. Complaint case, which was filed against me. That this complaint case is instituted upon the sanction order passed by the principal commissioner.
You'll have to make your voice little bit louder. You'll have to make your voice little bit louder. Your name, your name, please.
Paragraph 1, my lord.
Your name, please.
A.N. Ahmed.
Huh? A.R. Ahmed.
A.N. Ahmed.
Okay, please speak little bit louder. And take the mic properly.
Must kindly say page 22, my lord, paragraph 1, my lord.
Page 22.
22, my lord. Paragraph 1, my lord. That this complaint case is instituted upon the sanction order passed by the principal commissioner of the income tax, Digrugarh, Sri H.D. Mahanta, on dated 2018 for the assessment year of 2013, 2014 against the above noted accused SSC. Copy of the sanction order dated such and such passed by the Principal Commissioner of Income Tax, Dibrugarh is annexed here, annexed 1 million. But complaint is filed against me, my lord, that I have understated my income, actual income. Therefore, the income tax department imposed upon me some penalty and fine, my lord. And I have already paid all the fine or all penalty, my lord.
The complaint
imposed
was
upon me, my lord,
complaint was filed against CJM.
against CGM.
Then what happened?
It is still pending, my lord, before the CGM Kamrup Metro. My lord.
Now, what is the stage now? It was stayed, the proceeding was stayed.
Still,
No.
my lord,
Huh? Then what is the stage now?
still, my lord, it is pending, my lord.
Pending, I know what is happening there. What is the status now?
It is at the stage of appearance, sir.
Huh?
Appearance.
Appearance.
Pending. I have already paid all the penalty fine, my lord. Although the share is issued against me, my lord. Kindly please, my lord,
Where is that? That you have paid?
please, my lord,
What was the amount?
10
What was the amount? 51,000.
amount, my lord,
Understatement by how much amount?
my lord,
They're shown your lordship, their salary as they're shown their income as nil in the income tax return, whereas in reality the income was near about 7 lakhs.
7 lakhs.
Yes.
They come within the taxable
Yes, yes.
limit.
Because at the relevant
At that
period,
time, how much was there?
2,50,000 for senior citizen.
2,50,000.
2,50,000.
Then he's saying he has already paid the fine and all.
He has said he has paid the every tax, interest, and the penalties, your lordship.
Then what
But-
it means?
The lordship, but because of the understatement and for false verification in the return, lordship, the prosecution may be initiated by the department. That prosecution has been initiated.
my lord, kindly CPS 23, my
No,
lord.
you have paid, but they are saying that this
Amount
false statement.
determining against me, my lord, 6,24,930, my lord.
Now, what is your prayer?
There, my lord, for washing the share,
Why should I quash it?
my lord.
Why should this court quash it?
My lord,
Because that is as per the provisions of the law.
my lord, I have
Only by paying the amount, you may not be exempted from the penal provisions under the Income Tax Act.
I have already paid the.
Correct, but like still, I mean, as per the
I
provisions
have
of the,
I had already.
you paid after filing of the case.
Compound petition, my lord.
You paid after
considering my case,
filing
my
of the
lord.
case.
Payment was perhaps made beforehand.
Consider.
Payment was made beforehand.
Before that,
Before.
which is the law, relevant law?
The section 276(1)(c) of the Income Tax Act.
Income Tax Act. Sami ada? Hakotkan tu. Hakotkan. 9. You read 276.
That mainly two provisions are there: 276(1)(c) and 277.
1 second.
Yes.
276.
3 months to 2 years. 276(1)(c). For underreporting of income.
276A or what?
No, 276 subsection 1 clause C.
Out here, there is only 276, then 276A, 276AA.
Man.
Hmm?
76C.
Failure to comply with the provisions of 1 and 3 of section, no. Can you find out the proper section? Because 276, then 276A, B, A, 276AA, 276B.
Two 276C. 276.
You are saying 276 1C.
Lordship, I am mistaken. 276C.
So be them. Two 276C1.
Yes, sir.
Hmm?
You are 1C. 1C लिखा सर. This is for underreporting of income.
What is the threshold in 276C1? Check what is the amount? Threshold.
25 lakhs.
Huh?
20, in one, it is, in two, it is more than 25 lakhs, and in another one, it is less than 25 lakhs.
It says exceeds 25,000 rupees.
25 lakhs.
25 lakhs.
In both situations, different punishments are provided.
Now, 1 second. Then in other case, with rigorous imprisonment, other case means in
Less than
any other
25.
case, less than that.
Less than.
In any other case, with rigorous imprisonment for a term which shall not be less than 3 months.
3 months
Which
to
may
2
extend to 2 years or any fine. What happens? I mean, see, you have lost the case after payment of the amount, right? And after payment of the amount, for payment, have you issued some this thing?
Yes, Your Lordship. Notice was issued upon him.
Notice was issued.
Yes.
And he paid the amount.
He paid the amount, and then
Is there any provision once what happens once the money is paid?
No, Lordship. There is no, but however, after the money is paid, there is a procedure for compounding the offense. For that compounding, which has been provided, Lordship, in provision 279, subsection 2.
So what happened to that?
They had given one petition for compounding that was rejected because it was given after 43 months of filing of the case. There is a threshold that up to 36 months, there is a time limit of 12 months, but the AO may consider it up to 24 months.
However, with prior permission of the principal CCI, Chief Commissioner of Income Tax, in eligible cases, that 24 months may be taken up to 36 months. But their petition was filed after 43 months.
After 36 months, there is no other provision.
No other
provision. No power.
No power. So that was also that was rejected. However, they gave a second petition to consider the first petition for the reason that he's an old age person and he came to know about the proceeding
Provision.
very lately. So, and accordingly, on the last occasion, I was directed to take instruction from the department that whether what has happened about the second petition. My instruction is also lying in the file. Your
Now,
Lordship.
what is the instruction?
Instruction is that the second petition, in accordance with the second petition, an officer was designated who was directed to confirm whether his address was changed or not, and when did he receive the notice about the case, and what is the fate of that second petition. The fate of the second petition has not been informed by and accordingly they have directed that it has been deemed as rejected.
How it can be deemed as rejected?
But Your Lordship, one more question was put up by me upon the department. Only my instruction may be noted. Seen. Point number 4.
There is no instructions here.
On the last date, I had given that. May I show the record is given.
There is no instructions. Oh, yeah. Yes, point number 4.
Point number 4. My question was that, Your Lordship, that the department had filed was filed by the department on 27/2/2019. That the complaint was filed. Complaint was filed on 27/2/2019, and compounding application was made on 26/10/2022. However, during the period of lockdown, as per the suo motu writ petition by the Honorable Apex Court, certain period was removed from the for calculation of the limitation. That period was from 15/3/2020 to 2/10/2021. So if that period is removed from the calculation of the limitation for filing the compounding petition, this 43 months come to 31 months.
Then you can consider this.
They can consider this.
Then why don't you consider this?
But he will have to raise this issue before the officer.
No, he has already submitted this, second application.
Second application
And this is the Supreme Court direction is there that he'll have to exclude that.
Yes, sir.
Then why are you not taking consideration?
They have said that we may consider that.
You consider this.
That direction, if that direction.
You consider
But
this.
this is a quashing petition. For that purpose, writ would have been maintained.
Huh?
For that purpose, a writ petition would have been
There's
maintained.
nothing like that. He has come for quashing. The only thing is that now once you consider his petition,
Yes, sir.
then that proceeding can be withdrawn.
If the principal CCID considers this is an appropriate case, then that may be. With this observation, may be. Because this point was raised by me, because for genuineness.
He's an old person.
Obviously,
Then
and lots of medical documents have also been given. So this instruction was taken by my side itself. So it may be considered that if that observation is given, I may.
No, you take an instruction on this.
I have taken
and
already have
submit
taken
on the
that
next day.
instruction, and the instruction is very clear. First para is my question and the second para is the reply.
In view of the Honorable Supreme Court's order dated showing so delay in submission of compounding application may be 31 months as per 9 Once you do it, then we can quash your complaint also on the basis of this. That complaint that you have, either you withdraw or we'll quash it. If you take his application as genuine, 31 months if you take and consider his case for compounding, once it is compounded, then what
Once it
remains?
is compounded,
Then nothing remains. Then your complaint before this.
That we will have to withdraw that complaint from the.
Withdraw this.
Yes, in that case, we will withdraw. Instruction may be given to the for considering to the commissioner.
Okay, we'll direct them to consider your application.
My lord.
We will direct them to consider your application for compounding the offense.
Second application.
Maybe directed, my lord. The CR case which is pending before the CGM, my lord.
That will
Maybe
definitely,
withdrawn,
that,
my lord.
huh?
Maybe withdrawn
That will be withdrawn once they
by
compound
the,
it.
by the income tax department.
Once they compound it, then they will withdraw it. So should we dispose it of, or we should keep it pending? Mm, Should we dispose this petition, or we should keep? Huh? Dispose of with what direction?
Directing the authority concerned to withdraw the
You are
share.
not understanding anything, Mr. Counsel. You are not understanding what he is saying. He is saying that your first application for compounding has been rejected. Second application can be considered taking into account that excluding that COVID period because of Supreme Court's direction. If the COVID period is taken out from
Property application is rejected, although they have accepted the amount, my lord.
there is a provision by if there is an acceptance of amount also, this thing can be done. We'll dispose this off, and with the direction that
The second application be disposed of, whether accepted or rejected. The second petition for compounding,
accepted. What is there not accepted?
but that is the discretion of the principal CCIT. What are their condition to consider? Your Worship?
Then we'll have to keep it pending. Then we'll have to bring out, the result of that consideration. When you write, heard Mr. So-and-so, the learned counsel appearing for the petitioner, also heard Mr.
J. Chopra.
J. Kapoor.
Chopra.
The learned standing counsel for income tax department. The learned counsel appearing for the income tax department has submitted that he has received an instruction dated 3/8/2026, wherein in point number 4, the authorities has mentioned that that his first that the petitioner's first application for compounding the offense has already been rejected. However, a second application is pending with the authority, which can be considered taking into account of the fact that the COVID period that the COVID fact that that the period from 5/15/2020 till 2/10/2021 shall be excluded from the limitation. Shall be excluded from counting the limitation for filing any suit, appeal, application, or proceeding. Therefore, in the instant case also, that aspect can be taken into account, and if the period mentioned above is excluded, then the application of the petitioner will come within the range of limitation, within the limitation period. Full stop. In view of the aforesaid instructions.
Subject to principal CCIT's approval.
Huh?
Subject to principal CCIT's approval.
No,
The limitation is of 12 months, but principal CCIT's approval is up to 36 months.
Correct. Now, you consider this, if you exclude it, in view of the aforesaid, instructions, this court is of the considered opinion that the second application of the petitioner, which is the date?
Date of second application.
The date, which one?
Actually, the second application was not application. The second application is that kindly consider my previous one, taking the COVID period off.
Which is the date? That should be one application.
The date is.
Just give me a date. When it was filed.
30/8/2023.
The second application of 30/8/2023. 23. What is the line I have written? Get it?
Is 30-10-23.
30-10-23.
23. 2023.
2023.
30-10. I missed it.
30-10-2023. Shall be considered. Considered by the concerned authority. That is, who is the authority?
Principal, Chief Commissioner of Income Tax.
Principal Chief Commissioner. So, which range? Which region?
Northeast region. Principal Chief Commissioner.
Okay, Principal Chief Commissioner of Income Tax. Income tax.
Ania.
Income tax. Income tax and income tax following the following the provisions of law.
It is given there, Lordship. Para 9 of the compounding guidelines. My point number 4, second para, it mentions there. Following the compounding guidelines, dated.
Following the compounding guidelines, and accordingly, if the same is allowed as per law, allowed as per law, dispose of the same within a period of 1 month from 1 month from today. 1 month from today. After such consideration, a copy of the same shall be given to the counsel appearing for the petitioner, and the same shall also be submitted before this court. The matter shall be listed again after a period of 1 month. So you submit it, whatever the result you give. You consider his case and tell them, tell them to consider this. Because I cannot directly to compound this case. You cannot.
Actually, Lordship, the department has taken, I asked these questions beforehand also, but the department has said that it has become a normal scenario that after retirement, they never file the income tax return. They said, once I retired, why shall I file the income tax? Because there are lakhs of rupees are there in monthly pension also. So for
there is so many people you have selected him. Why?
it is one he has been selected because he filed nil return in that year.
Okay, then you consider this.
So I will
tell them, because I'm not directing anything to this thing, compound it directly, because that power I don't have. But tell them to do it. Consider this, and then you file this thing. Then we'll dispose of this.
Yes, sir.
With your submission that you will withdraw that.
It has been allowed.
The case will be listed after 1 month. They will consider your application, and we'll see what direction they pass. Okay.
One small request is there, Lordship.
Yes.
Kindly my name be reflected in the cause list.
Okay, the registry to reflect the name of Mr.
J. Chopra.
J. Chopra in the cause list as the standing counsel of income tax.
Yeah, 17 and 18 are the similar matters between the same parties. 17 is against the 125 CRPC maintenance and 18 is against the DBA. And the petitioner is in both cases is the husband and the wife is the respondent. So may I pray my lord to take up the item number 18 because it is the earlier one.
17.
Against the DBA.
18, how do you know DBA? 18. 18 positions there.
17 and 18.
18 positions are the same.
So 18 is the, my lord, against the DBA matter. And impugned order, my lord, dated 30th January 2016, passed by additional session in appeal, my lord. Prior to that, my lord, one DB case was filed by the wife, the respondent.
1 second. Yes.
So petition is, actually it was already heard and fixed for hearing. In that case, my lord, judgment was passed for payment of rupees 6,000 and it was in appeal, it was reduced to 5,000 and against that with another compensation amount of rupees 150 lakh. Against which this case is pending before lordship and
What is your prayer there?
my lord, first of all, first prayer is that to set aside the what is called
Compensation.
domestic violence. my lord.
Huh? Set
First
aside the
prayer is,
domestic
my lord,
violence?
to
Why?
set aside the original judgment,
Hmm.
whereas it is confirmed that there were domestic violence. My lord.
Yeah.
So second prayer, my lord, the compensatory award of rupees 1,50,000. So neither there was so original judgment regarding my lord domestic violence, whereas there is not a single evidence or anything else, my lord, showing that domestic violence. was there.
My lord, come.
You came to the sessions court. Then sessions court, what happened?
Amount was reduced, my lord.
Amount was reduced.
Yeah, from 6,000, it amounts to 5,000 per month.
6,000 to 5,000.
Yeah.
Okay.
This is the item number 18. That judgment is at my lord.
More 17 hours. More 17 hours.
Page number 20, annexure 3. And relevant portion is at my lord. Page number 24 of item number 18.
Now, page number 20 is the initial order, the original order.
Yes.
Original order by the SDJM, right?
Yes. And the
And
relevant portion is at
SDJM
page
passed the
24.
order in 14/8/2025, 2015.
My lord.
Then here, the direction was given to pay 6,000 rupees.
Yes.
To pay
That is
5,000 rupees.
Page 24, relevant portion. Order.
Pay
Page 6,000.
monthly payment of rupees 60,000.
No,
Or
6,000. Comma is there.
6,000.
Yes.
And
And
agreed. A monthly
compensation of
payment,
rupees 22 lakhs.
compensation 2 lakhs.
2
Total
lakhs.
mental and so and so. Oh, okay. Then against this order, you have gone to the additional session there.
Yeah.
The additional session judge order is at page which please?
Is my lord. 32. And relevant portion is at my lord 37.
37 regarding the quantum of maintenance. I have come to conclusion the appellant I have found no irregularity regarding findings. So only thing is that regarding quantum of maintenance, you have come 6,000 per month will be high amount the appellant compensation is so accordingly reduced to 5,000.
5,000. And the compensation?
2 lakh to 150.
Yes.
2 lakh to
50,000.
150. So now you have challenged this order before this court.
Actually, both order because as per my lord.
Both order means what? I mean, their earlier order has been confirmed. That means we'll have to challenge the additional, the additional session judge only.
Yes, but I am basically challenging that whether domestic violence was there or not. Firstly, and secondly, the compensation amount. Monthly amounts she can get, I have no, my lord, because she also have to survive. There is no doubt about that. And she is still getting, my lord, the 5,000 amount till now, regularly. But the compensation amount, my lord, 1,50,000, there is not a single, my lord, application filed by the petitioner. And if we go through the, my lord, evidence as well as the petitioner, followed by other things, no specific ground or specific time period is there showing that domestic violence was there. But in the meantime, she filed another petition under one
So
section.
where are those evidence? I mean, evidence are there.
Yes, record is there. LCR is there. LCR.
LCD.
Item number 18. So the husband is actually a teacher of a LP school. So this kind of allegation hampers his personal as well as professional life also.
Already hampered his life. Now,
Yes,
now there
that
is,
is right.
you cannot redo it.
That is kind of. At least in this forum, my lord, that part that no domestic violence was done, that declaration I received, then at least something would be there. Otherwise, compensation, monthly payment part, I am not telling. And he is still paying. But the compensation part is there.
Okay, you argue. Yes, you are ready.
My lord, what happened in this case, one order
You are appearing for whom?
passed by this honorable court. Where for respondent, my lord.
Wife.
Wife. Yes,
my
what
lord,
happened?
in this case, one order has earlier been passed, my lord, on 29/2/2016 by this honorable court, my lord,
Item number 18.
of item number 18, my lord. Heard, Mr. May I read, my lord?
No, which order?
Order dated 29/2/2016. 2016.
Yes.
May I read, my lord?
No, what is that?
Heard, Mr. S.K. Bharkotaki, learned counsel for the petitioner. This revision under section 401 CRPC is directed against the judgment and order dated 31/2016 passed by in Miss Appeal number 1/2015 by the learned additional session judge FTC Kamrup Rohingya under the provision of Protection of Women from Domestic Violence Act 2005, whereby the learned court below has allowed the maintenance amount and enhanced the compensation amount so granted by the lower court.
It
However,
was not enhanced.
Not that, it's fine.
It was enhanced.
Reduced actually.
If it has been written as enhanced.
yes, sir, yes,
It's the
ma'am.
first order of by
Because,
this honorable court at the time of motion.
Correct.
however, my lord, may I read, my lord, order.
Compensation so granted has been reduced to the extent of 5,000 per month,
Yes.
and compensation has been enhanced to one. It is totally, I mean, this is wrong order.
Typological mistake.
Yes, ma'am.
Then,
Then, my lord, however, the compensation so granted has been reduced to the extent of 5,000. 5,000 per month, and the
why have not you corrected this order? Mr. Nath, you should have corrected this order.
I actually have not controlled that typological mistake.
Hmm?
Otherwise, amount is there, my lord. What is there, that is
It
there.
is not typographical mistake, Mr. Nath. It's a wrong.
order.
5,000, that amount, 2 lakhs is reduced to 1,50,000. That is there, my lord.
50,000.
It has been stated that it has been enhanced to 1,50,000. It gives a different meaning. It says what?
No, it is compensation, my lord. It is
Correct.
monthly.
And compensation was what? 2 lakh rupees.
Yes, initially.
Then can it be enhanced to 1,50,000 rupees?
That is why I am saying, my lord, it might be a typological mistake.
Is it a typographical mistake?
Think so.
We should have corrected it.
Okay.
It is not typographical mistake. It should have corrected it. It gives a different meaning altogether.
But that is
Then-
mistake. Main
then-
thing is that that
Then,
is
then,
mistake.
then.
Consider the matters on record, issue notice to the respondents, returnable.
So
on
there is
six-
no stay as regards the payment of maintenance.
Yes.
But as regards the payment of compensation, the same is stayed
Yes.
till the hearing of the
And I
matter.
am paying, my lord, the 5,000. This
But you have not paid the compensation.
Yes.
Hmm.
And I am
Challenge
challenging
it.
that.
Learned
amount.
trial court. That trial court shall prepare miscellaneous file for payment of friends.
So this is just a motion order, my lord, staying the compensation, nothing else.
But this payment have, I mean, there is nothing.
That monthly payment has been
Paid.
paid till now. I have
Yes,
said
we said,
so what my friend is trying to say, I don't.
what do you want to say?
My lord, his order has been, yes, till date has been pending, my lord.
The disorder is still there, so you are paying it now. Now what? What do you want from this?
My lord, on the point of this payment, whether she received or not, the matter may be hard again. Matter may be hard.
Matter may be,
We have to
matter
take
we are hearing it.
instruction, my lord.
Huh?
We have to take instruction, my lord, of the party, the respondent, my lord.
Yeah, I mean, he's saying that you are there, you have been paid.
Well, I have all these documents of order. That payment has been already made
The payment is being made.
regularly.
Payment has been made. Oh, where is that?
I thought I have been paid there. I don't know. He's trying to convey, but I think he don't have the instruction. But my instruction clear, my lord. It is
Domestic violence, my lord, what happened, my lord? During the, while she was the wife, the respondent,
No, now, see, I mean, forget about everything. Now, whether you are arguing the matter or not, you just tell me that, don't waste court's time.
no, fixed for hearing, my lord.
This is for admission only.
Everything will be disclosed then. What
item number
happened?
18 has been already fixed for hearing.
How
As
domestic
because item
violence?
number 17, it is listed for admission, right? Because
Then both the matters, let the
Yes.
both the matter come
that,
for
that
hearing.
can be done.
Then you could have
That
said
can be-
earlier only.
No. Because there, my lord.
You could have said that other matter is fixed for hearing, the both the matters will be fixed hearing.
That can
Okay. Good. Very simple. Right, that heard Mr. B.K. Nath, counsel appearing for the petitioner. Also heard Mr. N. Ahmed, the learned counsel appearing for the respondent.
I'm for the 17, item number 17.
Huh?
I'm for the item number 17, my lord.
For whom?
For respondent, my lord. I'm for the item 17, it's for item number 18, my lord. So my present may be recorded, my lord.
Oh, 17.
I'm for the 17.
Same person, different lawyer.
Similar. 17 similar, my lord.
I mean, same person, two different lawyers, so what, into two matters?
My lord, 17 is for, my lord,
You-
materials under section 125 CRPC, my lord.
You are appearing for whom?
I'm appearing for the respondent, my lord. That is my lord.
Wife.
Wife, my lord. Saida
Ramina Begum.
Ramina Bhai.
That means like you are appearing in one matter he is appearing.
Yes.
Huh?
Yes, two items, my lord. 17 and 18.
So both matters can be fixed for hearing.
Okay, let both the matters be listed after listed for hearing, for hearing. And item number 17, you write his name. Or 18, write Mr. Ahmed, 17, write his name.
And in
Your
both-
name?
V. Baspo on behalf of B. Burma. V.
Who?
Baspo, Vinod Baspo on behalf of B. Burma.
Right. Okay. Both the matters will be listed after for hearing after 2 weeks.
In both cases, interims are there.
Now, if you want this, something, but that is.
Okay.
Probably the lord.
Yes.
The matter relating to rejection of Jima of the petitioner, my lord.
Jima of the
Jima of this Honda car, my lord, there
car, vehicle, cattle, what?
no, articles, my lord. Honda car, my lord, then there was Ford car, my lord, motorcycles and memory cards, many articles, my lord. What has happened initially, my lord? I was in a catch 22 position now.
You are what?
Catch 22, my lord.
Hmm?
Initially, it was this, your lordship may kindly come to annexure 2, my lord.
No, what are you, what do you do?
We are business.
See, Latif Ersad, what does he do?
Well, he is a businessman, my lord.
Businessman of what?
The petition number 1 he was a rig company, he was a safety officer, my lord.
Hmm?
Petition number 1 is the safety officer of a private rig company, my lord.
Safety officer.
Yes, my lord. A rig
And,
company, my safety officer, my lord. He used to look after the. And petition number 2 was working as
Safety or security officer?
safety officer, my lord. And petition number 2 was working as assistant engineer, my lord, ONGC.
Hmm.
And petition number 3 is his wife, my lord.
Hmm.
Way back in 2024, my lord, a FIR was lodged before the Simolinguri police station, where they were regarding, there was demand of money of 50 lakhs made by one Ganesh Axom. And on the basis of that,
Demand to whom?
demanding that by one Ganesh Axom demanding the name of Alpha, my lord.
Huh?
The name of Alpha, my lord.
Name of Alpha to whom?
To
Demanded from whom?
What? To an ONGC official, my lord.
Who is ONGC officer?
That has not been named, that is, big FIR has been lodged, my lord. Whatever it is, but we are not naming the FIR, my lord. On basis of that FIR, my lord,
See, foundation is the like this demand. So you have to tell me who demand was made to whom?
he says that they have gone to their rupees one signed by one Ganesh Assom demanding so and so. WhatsApp
See,
message they have
Kapil
received.
Bakal has filed an FIR.
Yes, my lord.
Alleging that he received a letter through WhatsApp, purportedly banned so and so,
So and so.
signed so and so. The matter was then informed to Simolinguri police station, but the extortioner is still at large. The phone number called so and so. It means so and so. The caller claimed that so and so.
Ultimately, my lord, on the basis of this FIR, my lord, the police, the police officers, they have raided my residence, my lord, and seized some articles, my lord.
Raided your residence?
Yes, my lord. That your lordship will find annexure 2 series, my lord. That is residence of Irsad Ali, this blue color Samsung mobile, then black color higher mobile, my lord, phone. Similarly,
Blue color Samsung, black color OnePlus, then light blue color so and so. Yes, then what happened?
then again, the next result is your lordship will find Bajaj Pulsar was seized, my lord. Bajaj Pulsar,
Bajaj
my lord.
Pulsar was seized from
And
your
then-
house only.
Yes. Then another colored, white colored Tata Tiger vehicle, my lord.
Correct.
Then Honda Activa, my lord.
Yes.
Then comes your CCTV footages, then PAN card and keys of Tata vehicles, my lord.
Then what?
These key, my lord. Key of the Tata vehicles, my lord. Then you'll also
Very good key of
that you'll page 22, my lord. Now thereafter again, there another seizure of mobile phones, my lord. There are laptops, my lord.
Okay, all these items were seized.
Yes, my lord. Now what has happened, my lord? After the seizure, my lord, the investigating officer, there's another case lodged against me, my lord, where I was named in the FIR. That case is your lordship in annexure 3, my lord. Page 36, my lord. It was lodged by SI Paramananda Soikya, my lord. Saying that
page 36,
my lord. He says that we have received from a reliable source of information suspected members of Bayan Alpha in a vehicle were carrying out the recent survey of location and slips out the district with the ulterior motive of carrying out subversive activities. Following this input, one suspect named Rishabh Latif, that is the present petition number 1, was picked up from Babupati. During interrogation, he revealed that he accomplished with Rahul Hazarika, Laden of Salfa, so and so, and the Hirul Islam Hussein, that is petition number 2, and driver
Okay,
Ali.
this FIR was filed, then what happened?
Then what happened, my lord? The Bokota PS, registered as Bokota, Nemoguri, PS case number 1124, my lord. This case has been succeeded, my lord, where petition number 1 and 2 were shown in the succeed, my lord. Now, thereafter, my lord, investigating officer made an application before the court, my lord, that your lordship will find that page, annexure 5, page 71, my lord. There says the case got put up before me on the strength of the petition dated.
1 second. What happened in page 71? What happened?
The investigating officer made a prayer before the before the
by an application. Okay.
The case record is put up before me on the strength of the petition dated 6/5/2005 submitted by Tushar Desai, SDPO Nazira, seeking permission for withdrawal of the searching number 1/25 submitted by Bokota and Emaguri PS case number 11/24 and modification of seizure list with reference to Simoli-Guri PS and resubmission of the modified charge sheet of CS number 1/25. Peruse the case record, peruse the case record, perusal will disclose the cognizance already taken in connection with Bokota and Emaguri PS 11/24 on the basis of charge sheet number 1/25 and accused persons have been entered appearance pursuant to summons. At this stage, permitting withdrawal and resubmission of charge sheet along with the modification of seizure list is not permissible. Actually, prayer is of the IO hereby rejected. Now what is actually the prayer was made when actually these articles are wanted in not in some of Simoli-Guri PS, in Bokota PS they are wanted. They are wanted in Bokota PS. So they made a prayer before they ought to have been received by the IO, but did not receive. They submitted charge sheet. So technically they want to modify the charge sheet and they want to reseize it.
So that is rejected.
Rejected. So we made an application before the court for seeking custody, my lord. That was also the page 72 last portion, my lord. For consideration of prayer, a David fit to call a report, so and so. The report was called for, my lord. Then after the report, my lord, that page 74, my lord. Report a requisition for consideration of custody of prayer. Since the report submitted by us stating that the seized article was seized in connection with Simoli-Guri PS. In said case, the register is Bokota and Emaguri PS. It is pertinent mention here. Aforesaid articles 1 not seized in connection with the said case, perusal case record, in view of the custody petitions were redundant and disposable. So then we filed an application before the session judge in connection with Simoli-Guri case 24 or 23, my lord. There, my lord. Then the court, my lord, passed an order, my lord. You'll also make kindly say.
75.
Yes.
Page 75.
75. Now, page 83, my lord, is the order, my lord. Today is fixed for report of custody of prayer or petition and custody of so and so. Report requisition for consideration of custody of prayer has been received, put up. Since the report submitted IO, report discloses the aforesaid articles are not seized. They have submitted that it was not seized in it was seized in Simoli-Guri case. Now they are saying they're not seized in Simoli-Guri. In view of the reports, custody of the petition says redundant and no order of custody is passed in this case. Now my vehicles are lying in the police station since 2024, my laptop, all the mobile phones are lying there, my lord. What a fault of the IO, my lord. Now I have to pay suffer, my lord. They ought to have received in other case, my lord. They did not receive, my court did not allow it now. And that Simoli-Guri PS case has not been charged, my lord. We are not naming it there as an accused in this case.
But how can you say that these materials were seized in connection with? I mean, these materials were seized in connection with
Simoli-Guri PS.
Simoli-Guri PS. But now, initially you filed an application for before the session judge for the Bokota case. Because Bokota case it was not seized, so it was rejected. So then you came to Simoli, then you came to the session court filing an application for Simoli-Guri. The Simoli-Guri court says what this.
The IO has submitted an application.
IO said that he has not seized those articles.
In connection with Simoli-Guri.
Simoli-Guri.
But actually, it clearly says that it was seized in connection with Simoli-Guri case.
What is that?
My lord, that is honestly speaking, my lord, I could not get the facts right, my lord. Now I from my learned friend's submission, my lord, what I could gather from that he is, my lord, agree by two orders. One is not allowing to withdraw the charge sheet and correct the seizure list, my lord.
No, he's not concerned with that now.
It's IO's fault, my lord.
Because now the seizure is, it's, my lord, whether the seizure list with Bokota and Emaguri or whether it is in Simoli-Guri PS, my lord, that is the, my lord.
No, our record says it is from Simoli-Guri.
Admittedly, my lord.
But the order says it was not seized in connection.
No, the order says because
Simoli-Guri. Because the IO said so.
Simoli-Guri PS, because record report discloses and perusal of the case record also discloses the same.
Let him take the instructions.
No, you can see the circuit also.
Press report,
let him take
both also, my lord, in the Bokota case.
I've seen that, Sarsit.
Yes.
They have relied on the seizure of Simoli-Guri, MR. So they relied upon that. That's why they're saying that we are.
But now I don't know now why IO has submitted that.
They ought to have, really, before filing the search, they have to make an application before the court. They will be allowed to
I'll
resist.
Let him
get a-
take instructions.
Get a report from both the police station, my lord, that from,
It is a matter of record, your lordship can see. He ought to have made an application before the court, before filing the search. Now, for the IO, for the purpose of IO, we are made to suffer, my lordship, can see.
You take instructions.
Lordship,
Since 2024, it is like that.
Lordship,
How can the IO make, IO can make this kind of mistakes?
Lordship, you know,
All these documents were seized, charge sheet is there,
yeah,
all, in connection with Simulguri.
Timur.
Then you go to the session court and
Ma-
say that like, no, that was not.
Search sheet is there, which is listing to my Nemuguri, man. Bogota Nemuguri, search sheet, man.
No, that was again said that like that will be.
That is the confusion, man. Some search sheet is, I have seen, man, search sheet is for Bogota Nemuguri.
But the documents were relied on Simulguri.
You take the instructions.
No, that is what I am also, my.
You take the instructions.
Lordship.
We'll fix it for hearing, then let him take the instruction.
The law sorted by fixed by.
When can you do it?
Man, not very sorted, my lord.
By-
At least after
there's
the,
confusion, let him take some time.
yes, at least after the 15 August, my lord, they did.
15 hours also too, it will be too early. I don't think
Lordship,
we can clarify so easily.
Lordship, my lord.
It's very confusing.
Lordship, on 27 or 28,
First week of September.
first week. Third, my lord, third, there are only 2 days court, my lord.
7th of September. 8th
Seventh,
of September.
7th,
8th of September.
8th of, Lord, and
Mr. P. Kotak,
deeply obliged.
Senior counsel appearing for the accused applicant. Appearing for the petitioner. Insisted by so and so, and also heard Mr. MP Goswami, learned MP for the state. Mr. MP Goswami prays for some time to get certain instructions involving the instant case. This prayer is allowed. Let the matter be listed on 8th September. For hearing or admission.
Admission.
Otherwise, my cars and my scooter.
But there are a lot of confusion.
Lot of
That has to be clarified.
Report made by the police officer, man.
No,
They're relying on documents which were seized in another case, man.
Yes, that is what. And like that Ladakh session judge also can't do anything because that was a submission made. He also probably didn't.
Yes.
He could have seen this.
Yes.
But now order is there, let him.
Do one thing, my lord, you can remand the matter for session judge for fresh consideration. That can be also done. Otherwise,
Let him take the instructions, then
Yeah.
we'll remand it if required.
That is.
Next day.
Yes.
Next day, let us see. If they cannot clarify it, then we'll have to send it back to session court
Yeah.
for clarification.
because admittedly it is seized in Simagoli.
It's a different case, different.
We are not accusing this case, man.
Then we'll remand it for, like fresh this thing.
Yes, yes.
Let him take the instruction.
Item 20.
May I, please, your lordship?
Yes.
My lord, this matter is also relates to Jimma, my lord. 24 numbers of buffaloes, my lord, had been seized. And my lord, we approached the learned trial court below. And the learned trial court below, my lord, by of an order, had directed the allow our Jimma and directed to release the, my lord, seized buffaloes. My lord, I am straight away drawing my lordship's kind attention, my lord, to page 133 annexure 16, my lord. Page 133, my lord.
Here one report is called for, but it is
Yes,
not received, my lord. Today. A report is called for, but not
My
received.
lord, the police report.
Not received, my lord.
Call for, but my lord, the case is very clear, my lord. The IO is trying to, my lord, review the order of Jimma.
IO's report is not there.
Not there, my lord.
Then we cannot hear it.
Lordship.
Heard Mr. A.R. Bhuyan, the learned senior counsel, assisted by so and so. Also heard Mr. MP Goswami, learned AP for the state. Police report, the IO's report regarding seized buffaloes is yet to be received. Now it is with whom, this thing?
My lord,
The buffaloes are with whom now?
my lord, the buffaloes are in the, my lord,
Custody of?
custody of the, my lord, Gosala, my lord. It is in, my lord, the custody of Gosala Jyoti Enterprise, Nagaon, my lord. My lord, my instruction is that the condition of these buffaloes is deteriorating and may happen. So,
But there are allegations of, I mean.
no, no, my lord,
wrongful termination.
actually, my lord, the learned trial court satisfied that I am the absolute owner of the buffaloes, my lord. That's why direction to release the buffaloes forthwith. But the IO says, my lord, that some other owners has, my lord, come up. It is the proxy owners, my lord, has been projected by somebody, my lord. That's why, my lord.
Let us see, I mean, let
Yes,
us see.
my lord, my humble prayer.
IO is not received, so
Yes.
the report of IO is not received regarding the seizure of the buffaloes. Let the matter be listed on when?
Last week of August, my lord.
Well,
Or my last subject to last week convenient.
3rd of September.
3rd of.
3rd of September.
obviously.
This is for quashing of the CR case. Including the order taking cognizance under section 314 of the PNS. Lordship, this is actually purely a civil case which has been given the color of criminality, Lordship. The basic facts of the matter is that it managed from a contract which was executed between two companies.
Please use the mic, my mic, please. Yes, yes.
Lordship, this is purely a case of civil nature which has been given the color of criminality. Lordship, this entire dispute that arises is emanates from a contract between two companies. It was for sale and purchase of a wet mix plant. The petitioner herein is merely an employee of the company, and the respondent is the proprietor of that company. Lordship, in the year 2023, this respondent visited the company where the petitioner works for purchase of this wet mix plant. The negotiation happened in Gauhati. They negotiated, and then the company decided to sell that plant to this person. And the person sent money to the Gauhati branch of that company, and that wet mix plant was sold to that respondent. Lordship, I'd like to take you to the invoice. After that, an invoice was raised wherein a clause was given that before sending.
You have come for what? Washing?
Yes.
Washing of the affair.
The complaint case.
Complaint. Where is that complaint?
It is in page number
Annexure
18.
2.
Annexure 1.
Yeah. Let him get straight.
Yes.
Lordship, if I may take your lordship to annexure 6, page number 45. It is the invoice.
Mm.
Lordship, you see the name of the buyer and seller, both are companies. And here, Lordship, at clause number 4, terms and conditions, there is a condition that buyer shall depute their representative at the time of loading the material. We have been requesting the respondent time and again that you depute a person, but they did not. As such, we sent them a notice, a letter. It is on the next page, 46, page number, annexure 7. Lordship may come to the second paragraph. Accordingly, a pro forma invoice was raised on so and so.
No, why I mean, why this deal got into such this thing? Why the deal has been broken?
It's not broken. We are ready to give the machine, and we are even saying that if you want the
You are ready, but like he is not willing
he
to
is
buy
not
it
willing
now.
to come. No, he has already paid. We are
He has
saying
paid
that
the money. Now he wants it back.
he wants it back. We are ready to give that also.
Then why are not giving?
Because he has to come, he has to take it also. He is not coming. He has gone to this extent of doing this. We have sent him letters also reminding him that you come, you depute a person, because without deputing a person, we cannot send you that machine.
Machine you could not, and as far as the money is concerned, whether he has written a letter to you.
No, for the money, he has not given a letter, but he, in the initial deposition, he has said that he wants the money back. We are ready to give that also.
We have communicated to him.
We have tried communicating to him, but he is saying.
But
that
is there any written communication
no,
with him?
there is no written communication with regard to that we want to send the money back. But Lordship, while taking the cognizance.
Yes, why don't you
Lordship,
take it?
I'm appearing for the as an amicus in this matter.
Mm.
Lordship, if your Lordship comes to page 29, that is annexure 2 of this case, my lord, here the
You are appearing the amicus for the respondent.
yes, your
Why he is not appearing?
He
Lord,
knows about this case. He is appearing
Lordship,
in the trial.
on the last, if your Lordship sees the last order, I have been asked to appear in this case, my lord. I would like to bring to your notice, my lord, first of all, that the machinery which is there, which she's talking about, the machinery which is supposed to, which we have, which the 8,37,952 has been paid. That machinery has not only has to be transported to the buyer, it has to be also installed. So they and the my lord, if I can, my lord, if your Lordship comes to the page 45, kindly come to page 45. The same thing which she has read, my lord, which is a representative at the time of loading of the material. So, my lord, at the time of loading from the seller's
So
place,
you need to verify the thing. And
exactly, my lord.
Yes,
And they have to come and they have to install.
You have not sent anybody.
And they haven't, and they have to install the thing. And my lord, it was, if your Lordship sees, it was 23. Now it's 26. And my lord, at this stage, 18-2, my lord, 26, the cognizance has been taken regarding, cognizance has been taken under section 314 of the BNS. It is, my lord, this thing offense, my lord, up to 6 months or to 2 years. So let them face trial, my lord. At this stage, it is as a nascent stage. So let them face trial, let them deduce evidence, whatever, my lord, and it will come to a logical conclusion, my lord. Directly coming to the High Court, my lord, at this stage, my lord, because it's an nascent stage, Lordship will not interfere at this stage because it's a nascent stage. If your Lordship sees what they have challenged is at page 34. If your Lordship sees the order which they have challenged, my lord, which is 18 February 2026.
Yes.
Complainant is present and his initial statement under 223 BNS is recorded. And statement of the complainant's witness under so-and-so BNS is recorded, and the same are to be annexed with the case record. I have perused so-and-so petition and statement so-and-so on finding incriminating materials against the accused Deepak Sharma. I deem it fit to take cognizance or under section 314. So at this stage, my lord, cognizance has been taken. It's at a nascent stage. Let them face trial. Let them go there, my lord. And I believe, my lord, have been informed that the next date for this thing is 110, 1st of October, 26. So let them face trial, my lord. That is my humble submission.
Lordship, if I may, quote your judgment itself, which was to be followed in this case, no notice was issued to us before taking cognizance. Lordship must see that. It was, cognizance was taken after that summons was given.
Notice is required in this case. Notice is must.
That part, my lord, I leave it to your lordship, but
Lordship, even
as
jurisdiction.
on, my lord, as a amicus, I am just pointing out all the facts, my lord. That a particular thing, a deal was done, my lord. They have been sitting tight, my lord.
I'm not sitting.
They are,
that
they
I'm
are
saying it is
representative, they're just relying on the representation, representative part. At this stage, my lord, it's, my lord, in an essence stage, my lord. Let them face trial, my lord. Let them place their case before the appropriate court, my lord.
Lordship may also appreciate that this is a case out of jurisdiction. No inquiry was done in this matter. No notice was
No,
sent.
it's not required, not required. I mean, see, there was a deal done, there was a contract, in fact.
Yes.
There was a contract, as per the contract, you should
Yes.
deliver this and like install it.
Yes.
Whether you have done it.
Lordship may kindly see that term.
No,
that,
whether, see, this is a plant.
yes, someone
Plant
has
means
to come.
you'll have to go and deliver and install it. Then only the person who has bought it, he can use it, utilize it.
Lordship,
But you have not done it.
Lordship, that could be done
Hmm.
only if the buyer could send a representative. That is the terms and conditions written. Clause number 4 says that he has to send a representative. It is a huge plant. If they do not come and check that these are the things that is in proper condition or not, we cannot send it. Because once the plant
and
is
You
being
settle it. Yeah.
And one more thing, my lord.
Settle it
This
between
is
you. You settle it. What, I mean, why
the
you are
person
fighting for
is
this thing?
interested in harassing us. That is what he said, because after reminding him quite a few times.
My
he
lord,
said,
how are you harassing them, my lord? 8 lakh 37,000 hasn't paid.
See, I mean, there is no question of harassing you. Money is with you. The plant is with you.
Lordship, if I may submit in
No,
that.
you submit. You are, who is stopping you?
Sorry, Lordship. It is the condition.
You have taken the money.
Yes, I have taken the money.
The plant is with you. Now you are saying that you are being harassed. By harassing what? With pistols, with
filing this
rifles,
petition
what?
because we have already reminded them quite a few times.
Hmm?
If we see the letters,
Hmm?
we have reminded them. Lordship may kindly see the letters
Hmm.
that we have reminded them. At page number 46, there is a letter. At page number 51, there is a letter.
When did you write it?
It was on 12/6/24. We have reminded them orally before. When they did not do it, we had to file this letter. We had to send this letter. Lordship may kindly go through this part also at page number 47. Therefore, I would like to humbly remind you to arrange any of your authorized person to visit our premises and pick up the premise from within a period of 15 days. Otherwise, we'd be left with no option but to forfeit your money as well as charge the expenses for using our premises to store our machinery. Alternatively, you may authorize us in writing to send the VMM plant components to your site on your behalf. We will cover the cost of loading and transportation. We have reminded him. Next.
Are you in touch with this guy?
My lord, I'm not in touch because I have been just given the thing, but I was told by one of the persons, there was one that was representative was sent earlier once, I think, but then they were not in touch, my lord. They are not cooperative.
Can you get in touch with this person?
I will try to, my lord. If
You get in touch with this person
My lord.
and find out what is happening
My lord.
and tell them that let's settle this.
Settle this, my lord. And one more thing, my lord, I just want to point out that in the thing they were saying that they wanted the money back because of the fact that she had said
No, those
the
things will be-
machinery was kept outside.
Those things will be
open
taken care of. I mean, those things will be taken care of.
My
You
lord.
just take some, you get in touch with him.
I'll get in touch.
And come back with the instructions.
My lord. My lord, we
Tell
can
tell him to settle it.
My lord, that'll be better. Monday, my lord, if your lordship can fix, I'll try to get some information.
I take it Monday.
Otherwise,
Tuesday, whatever.
my lord. Because as it is, the lower court date is, I think, on 1st of October. So there is time.
You take some more time if required,
Fine.
but like you take some concrete this thing because
My-
there's no way fight
My lord,
between these very unnecessarily
my lord.
doing these things. Yeah. Heard Mr. N. Nazmin, the learned counsel appearing for the petitioner, also heard Mr. A. Fukan, the learned amicus curiae, amicus curiae appearing for the respondent. Mr. A. Fukan, amicus curiae is guided to get in touch with respondent, with the respondent and get the instructions, get the instruction as to get the instructions as to whether the matter can be settled outside.
Right.
Whether the matter can be settled or not, you just
My lord.
take
I'll get
this
my
thing. Let the matter be listed on 20th.
Deeply obliged. Deeply obliged.
20.
Of this,
August.
Lordship, could it be a different day? some other date, Lordship.
Okay, fix it on 25th.
Keep the average.
Made clear, your lordship, my lord. My lord, due to time constraint, my lord, I pray, my lord, this matter will fix next Tuesday, my lord, because trial court matter is already fixed on 27, my lord.
I too was seeking time because this matter was supposed to be argued by the additional AG, Mr. P.N. Goswami. He's out of station today. Any short date, my lords.
Next Tuesday, my
He's
lord,
also asking for the same thing.
Same thing.
because of the
So
time.
it's not required to be repeated.
I was just gonna say.
Okay, Mr. D.K. Das, the Learned Counsel, appearing for the petitioner. He is present for the petitioner.
Yeah, we're.
Mr. Pope, E. Katoki, the Learned Senior Counsel,
appreciate
a special prosecutor for the chief initial grievance sale as well as, your name is?
S. Sharma, my lord.
We also appearing out of the special public prosecutor in this case. ma'am.
S. Sharma, the Learned Counsel
Yes, that is
for
also-
PhD department, my lord.
PhD department. You are respondent number?
Two, my lord.
Respondent number 2. On the joint prayer of the council appearing for the respective parties, let the matter be listed on
18th, my lord.
18th.
Yes, my lord.
18 to, I think lot of matters have been fixed. We'll take it up
My
on
lord, 20 then, my lord.
20.
Obliged, my lord, deeply obliged. 20, my lord. Deeply obliged.
Okay, there is also available.
Is there to be retained?
Yes, right.
You retain it, when you get, or you want to send it back?
No, no, no.
Not required.
No, no, Sarsi already submitted.
You retain it then.
Yes. Our name to be report.
41. Obliged.
This case else, issue was called for, but it's not received.
Issue not received?
Conviction.
Okay, Mr.
By order, it is 17/7/20.
Mr. S. Islam is present for the applicant. ECR in the instant case is yet to be received. Let the matter be listed on when
Last week of
last week of August. Let the matter be listed on let it be first week of September. Third of 2nd of September.
second. Yes.
42.
Anybody is appearing? You are appearing?
Yes.
Yes, what is that?
I'm waiting for respondent number 2.
Will you come to the set? Who is appearing for the petitioner?
Petitioner in person, perhaps not appeared.
None appeared for the petitioner when the matter was, applicant when the matter was called for, let the matter be listed. Let the matter be listed on 9th September.
43, 44.
It will be no more.
Yes.
Your lordship may kindly peruse the last order. Probably your lordship, since they have made them parties, your lordship. In the complaint, we made them party, we made him party, the staff report. So without hearing him, without service on him, matter may be hard, your lordship. Because your lordship, it is purely a question of law. And your lordship has already decided this issue, 223, your lordship, without taking the evidences, your lordship, at the initial deposition, your lordship, whether notice can be issued or not.
No, now respondent number 4 is who?
Staff reporter, your
Hmm?
lordship. Staff reporter.
Staff reporter.
They have made him party in this manner, your lordship, in the complaint, and therefore we have to, your lordship.
So what is your thing? Like respondent number 4 is required?
If lordship looks at page 26, lordship, this is the part of the complaint, 26, lordship.
if Lordship peruses the last 4-5 lines of first paragraph, Lordship.
Last,
That accused number 5 in the middle portion, Lordship. That accused number 5 is one of staff reporter of Assamia proceeding who reported the news item in concern and whose name has not been disclosed by the newspaper, and the other accused are to disclose her name at the relevant point of time.
no, what is this? What is this?
So this is the complaint, Lordship.
Complaint.
Yes, they are praying for quashing of this complaint, Lordship. So I'm not aware what is the name of the staff reporter, Lordship. So statement has been made in the complaint itself, Lordship. At the relevant point of time, they will disclose the name. Their party here, Lordship. Other respondents are party. Other accused persons are party here. So Lordship may definitely issue a direction to them. They disclose his name.
In that case, your lordship, the learned senior counsel appearing for the particular.
Yes, Lord.
Will have to be hired.
In the other case,
Who
Lordship.
is appearing?
Number 43, and we are a petitioner in item number
44.
We are challenging the same individual.
Yes, Lordship. In the second case, Lordship, item 44, this is complainant number 3, Lordship. Accused number 3. So accused number 3, Lordship,
We'll hear it some other day. We'll fix it some other day. Let Mr. Kamal be also there.
Yes, Lord.
Then we'll hear it.
The only issue is that, Lordship, one interim order is in effect, Lordship, and the proceedings below, Lordship, has been stalled.
We'll fix it.
Lordship will fix a short date, Lordship. Or otherwise, Lordship may direct them also to disclose the name of the staff reporter.
That will let him hear. Let him hear.
Yeah.
Okay, heard, Mr. The parties are same, no?
No.
The councils are same.
Council.
Both the cases?
Yes.
Okay, 43, you can write, heard Mr. S. Bhattakur, the learned senior counsel, assisted by P. Khatonier, the learned counsel for the petitioner. Then you can write Mr.
Lordship, in this.
You were also there.
Yes.
For respondent number on behalf of Mr. So-and-so 1, 2, and 3. And then
I am appearing for respondent number 5 in 43, Lordship. 43, Lordship.
Mr. P. Nayak, you are appearing as what?
As counsel, Lord.
Counsel. Mr. P. Nayak, P. Nayak is appearing.
In 43,
Mr. P. Nayak, Mr. The learned counsel is appearing for respondent number
5 in 43.
5 in 43, yeah, 5 in 43. 5 in 43. Then 44.
In 44, I am the sole respondent.
44, he is the sole respondent, P. Nayak. And 44, you are appearing for Mr. Bhattakur is also appearing.
I am not there.
You are not there. Kamal is there. Mr. So-and-so on behalf of that Kamal is present. Your name? P means? Parthiv Dev Chaudhary. Okay, P. Dev Chaudhary, yeah. Then you write, let both the matters. You write, let both the matters be listed on.
In the September.
When do you want?
This 2nd of September.
Today is today is 12, Lordship.
2nd of September.
Lordship may take it up on 26 also, if possible, Lord.
I have some difficulty.
We'll fix it up 10th of September.
Lordship.
10th of September.
10th, your lordship, number of cases fixed.
Huh?
On 17th, your lordship. 17th.
More than 1 month, Lord. I'm praying for
15th of September.
Lords.
15th of September.
Obliged, Lord.
Deeply. Interim orders will continue.
Okay, interim order so passed. In both the cases? Or one case? Both the cases. Okay, interim orders in both the cases.
Deeply open.
May it please your lordship, I am appearing on behalf of Mr. A. Apologies, your lordship, steps wouldn't be taken earlier, it was taken today. Apologies, your lordship, steps wouldn't be taken earlier, it was taken today, your lordship.
Okay, the learned counsel appearing for the MS, your name, give.
FP Chaudhary on behalf of Mr. A. Ahmed.
So means that steps in the instant case has been taken today. Let the matter be listed after 3 weeks.
Your lordship, interim was granted.
Interim order, so passed earlier, shall continue to the next.
Much obliged, your lordship.
There in terms of Lojima Court order dated 7/8, service to the private respondent 2 is completed.
I am appearing for that private respondent 2, Lordship.
And the matter may be fixed for admission next week. There, my lord, I have challenged the order granted.
As per Lojima Court order dated 7/8/2026, the service upon respondent numbers.
2, Lordship.
Respondent number 2 is complete. Mr. P. Datta.
PP Datta.
PP Datta. PP Datta, the learned counsel has put in his appearance for respondent number 2. Mr. Alaji, Mr. A.I. Uddin is present for the petitioner. Let the matter be listed.
I want to file on response, Lordship here.
The matter fixed on 17 September
For admission.
for admission. In
meantime-
the meantime, the learned counsel appearing for the respondent number 2 shall file his objection.
Obliged.
Obliged.
May I please, your lordship? Lordship, this is a quashing petition. A notice was issued on respondent number 2, my lord. That notice duly served. So your lordship may appoint amicus curiae or my lord, legal aid counsel.
We'll have to wait for one more date because it was served very recently. So,
17.
Hmm?
17.
What? Not 17.
That second file that notice there, police station.
Second file, second file. But till 27, it was not served.
Oh, yes.
Then
That no, but that report received now. One 7/26, that is my good. That IO notice there, my lord. You will start this.
where is the date?
That is that,
I so and so do hereby certify that when a FIR has been duly communicated to informant parents of so and so and bail. No, there is no date.
that I've seen.
You have seen any date? Have you seen any date? No, there's no date.
The thing, maybe mistake, but I thought that that 17 signature of IO and then below that, I think.
Inspector so and so. Witness.
That was that. It was.
No date.
I noted there, I do not know.
No date. Let's wait for. Let's wait for another date, because we should give the opportunity. No? This is what POXO matter about.
POXO section is
The
there.
POXO matter informant is required.
That's
So
why
that is
notice
why-
already served.
That is why, I mean, we'll give some more time. Okay, heard Mr.
B.B. Gogoi.
B.B. Gogoi, the learned counsel appearing for the petitioner. The office note dated 30/7/2026. reveals that notice is duly received by the respondent number 2. Respondent number 2, full stop. Let the matter be listed on, I will give you a
That
thought.
may be given, my lord.
Let the matter be listed on 19th August. 19th August.
August, yes.
19th August, if nobody appears, then we'll appoint
Yes.
one chance they should be given.
We'll have a case for extension of time, Miller Lordship's order
Huh?
is placed 10 Miller. Directed the petitioner to appear before the planet court below.
They will cancel it.
I said 15 days. But due to some unavoidable
No, we'll cancel it.
circumstances,
I mean,
I am
after
speaking
getting the
paragraph
bail
3
also.
Miller.
This is not, I mean, whose order is this?
Yes, Miller.
You go to the appropriate court.
Page 10 Miller.
You go to the appropriate court.
Yes, Miller, sometime maybe granted due to flood affected area, Miller. That's why he could not communicate and come to ask us.
15 days time was given. In
Yes.
spite of that, no.
Yes, further 3 or 4 days, Miller.
No.
Only they will appear and.
No. You are taking all these things. No, will not give.
Kindly paste.
Will not give.
Page 4 Miller.
Will not give.
Para 3. Kindly see page 4 para 3 bottom Miller. And they are willing to remote area, shore area. That's why they is the flooding, that's why they could not come. And they are ready to appear. And they were earlier in the jail Miller.
What is beyond their control?
Due to flood, Miller.
Flood where?
What is the flood?
Flood where? Where flood?
Miller, their area.
No, which area?
Miller, this area, Miller, Vishwanath area.
Vishwanath, there is no flood.
Kalakati.
Vishwanath, there is no
Chor
flood.
area, Miller. That is the Chor area.
He said, no, there is no flood.
Actually, Chor area, Miller, all 6 months is underwater. Only
Right, how Mr. A. Ahmed, the learned counsel appearing for the accused applicant, appearing for the applicant. Also heard Mr. MP Sharma, MP Goswami, learned AP for the state. The instant application has been filed for extending the time period given by order dated 9/6/2026 for appearance before the jurisdictional trial court. Jurisdictional trial court in connection with December Charlie PS case number 54/2026. The learned counsel appearing for the applicant submits the due to flood. Due to heavy flood in the locality of in the locality where the applicant resides, they could not go and appear before the jurisdictional court, which court?
CJM Vishwanath.
Jurisdictional court, that is CJM Vishwanath. Within 15 days of passing of the order with 9/6/2026. Therefore, he faced that some more time should be granted to him for his appearance before the jurisdictional court. Taking into account the submission as well as the explanation given by the accused, by the applicant, this court directs the accused applicant shall appear before the jurisdictional court within 7 days from today. This order may be read as part of the order dated 9/6/2026. In terms of the direction, the instant application is disposed of.
Okay.
Yes.
Lordship, I am for respondent number 2, Lordship.
Non-appears for the petitioner when the matter was called for, let the matter be listed after 3 weeks.
3 weeks.
Repeat, 52, 51.
In the online matter, respondent number 2 has filed their affidavit yesterday. In the online record matter, it is showing that respondent number 2 has filed their Vakalatnama yesterday.
Who is appearing?
Mr. M.R. Sodier, matter, as per.
Okay, Mr. So-and-so is present for the petitioner. However, none appeared for the respondent number
2.
Respondent number 2. Is it something to do with POCSO matter?
No.
Respondent number 2, Mr. MP Goswami is present.
Yes.
APP is present. Let the matter be listed after 2 weeks.
Much.
Wait, please, Your Lordship, in this case, Your Lordship, you directed to take steps on respondent number 2, Your Lordship. We have taken these steps.
Lordship, I am for the respondent number 2 and 3.
So complete.
Yes, sir.
Okay.
Lordship,
the-
we have received the case yesterday night.
Hmm?
Yesterday night, we have received the case. Lordship, I pray for some time to file objection also.
I have Mr. T. Dori, the learned counsel appearing for the accused, appearing for the applicant. Mr.
I Bhattacharya,
I. Bhattacharya appears for respondent number 2.
2 and 3.
2 and 3. 2 and 3. Mr. Bhattacharya submits that he should be given some time to file an objection in the instant case. His prayer is allowed. Let the matter be listed after 2 weeks.
May I pray, Your Lordship? This person is behind bars, Your Lordship. He has been arrested and he has been.
So he's going to file an objection to that.
Yes, sir. So may I pray for a fixed date?
No, 2 weeks. 2 weeks. He want to get detail.
Second. 28 months.
Let it go. A lot of matters in fixed, Mr. Deori. Let it be on second only. Otherwise, it will be existing.
Much of that.
May I please, Your Lordship? I'm sorry, my lord. Item 52, my lord. CD is there, so my lord, can I fix that or Lordship may kindly?
52 means for this one.
Yes, 52. Earlier case, earlier item, my lord.
Earlier item,
That
this
is,
order.
it was fixed after 2 weeks, my lord. So CD.
No, nobody was there.
No, my CD is there, so my lord, whether CD we have to send back,
So CD, you keep it. I mean,
because it will keep, because if it not listed.
okay,
so
2 weeks that I get.
Any, can it
We
be?
are giving it,
maybe
huh?
given, one date, my lord. Can I?
28.
2/8.
Lord.
Yes, sir.